And one more, just file matter. Yesterday, your lordship, one matter I moved. You have to score the item number 57 of the supplementary list. Exactly the same matter, same cooperative society may be allowed to come tomorrow in the list.
Tomorrow.
Tomorrow.
Just let me check.
May it please, Your Lordship.
Just a moment, Mr. Sharma.
Yes, my lord.
Tomorrow 54. Not tomorrow, Monday. Tomorrow, there are already 54 matters listed.
No, but same order will pass. Yesterday, Mr. Cancelled the moved one item. Same order. Just it will take 30 seconds. Same court society. One party is moved by Kenjoti, one party I moved.
Achha, okay.
How
Okay.
will yesterday's fishery.
No, it's okay. I'm just looking at the calendar. I don't remember the matters. Yes.
My lord, two matters, my lord, I'm praying for withdrawal. It may be taken up on Monday, Your Lordship. And another.
Our
three
place for
matters-
listing, please give it to the court master.
My lord, 3 matters, it was not listed, 2018-19 matter. In
Give
the
give
month
it
of
to the
August,
court
my
master.
lord,
He'll have to make some adjustment when you take it up.
Your Lordship, this is a mention for production of the item number, petition C2899 of 2023. Your
Give it to the court master. Place for listing, give it to the court master. He'll have to make some adjustments.
May I please, Your Lordship? This is a matter regarding, my lord, a no confidence motion of, my lord, the Panchayat, my lord. The notice has been issued by the BDO on 14th, my lord. It was received by me on 19th. I filed the case yesterday, my lord. Today, my lord. The meeting is tomorrow, my lord. Can it be today, taken up today, my lord? Second half, my lord.
Today. Okay.
Deeply obliged. my lord. Another matter, my lord, this is an electricity dues, my lord. There is a threat of disconnection, my lord. Can it be tomorrow, my lord?
No, Monday.
Monday. Obliged. Item number 1 of part 2 hearing list, my lord. My senior is out of station for today and tomorrow. I'm praying for accommodation only for these 2 days. Maybe call on from Monday onwards. I have taken consent of the government.
Part 2 list.
Part 2 list, item 1.
Just a moment. Part 2 list. Okay. You're taking consent to the other side?
Yes, I have informed the government councilman.
Okay.
Only for today and tomorrow.
Okay, next week. Call it next week. Okay. Yes, Mr. Chauhan.
My lord, the item number 1 and 17, supplementary 17 has been already tracked by law.
Pardon me?
Item 1 and 17. Supplementary 17.
Yes.
My lord, I have to file my lord additional liquidated in this.
Okay. 1 and 17.
Yes, supplementary 17.
Okay. 1 and 17. On the prayer made by Land Council for the petitioner, Maristan is adjourned today. List after?
Next week. Next week.
List is the next week.
Hello, item 10 has been shown in orders. In fact, my lord, last time order was passed for disposal of this matter.
Item?
Item 10.
10.
That time of admission, my lord, after
Just
admission,
now.
they are will
Just now.
take it up. I, my lord, all parties agreed that the entire matter can be disposed of.
Oh, yes.
Much.
I think your part is over.
My lord,
Your part has been heard.
no, not hard, my lord. No.
No.
The IA, all the parties agreed that.
Oh, achha. Okay. Okay. Okay.
As regard item subject to you, what your lordship may say, item number 19 and 20, actually one item only. So there is an urgency because your lordship directed that you may file tender, but final decision will not be taken. I leave it to your lordship, my lord, if you can.
We'll try to accommodate. I'll try to accommodate today.
Yes. 2 o'clock after 2 o'clock.
I'll try to, I'm not giving the
Why?
time, but I'll try to accommodate.
I'll not take much time. It's a
Because
short
the election matters are there.
election matter.
That's why.
That. Then we have little chance. Well.
I'll take it up. I'll try to take it up.
If it is not taken up, then if it cannot be taken up, it should come up once.
No, I don't know. We don't know whether the board, will continue or it may fall also. We don't know.
I'll leave it.
Supplementary was list item number 14 and 15, delivery of orders.
WPC 8353 of 2022 is dismissed. WPC 2189 of 23 stands partly allowed by setting aside and questioning the work order of 19/4/2023. Order of interim order of 3/5/2023 is made absolute. For the balanced procurement, a fresh tender may be called, or alternatively, competitive rates may be obtained from the bidders, existing bidders. For suppression of facts in the 8353, we have imposed 25,000 as cost. And this money will go to the Guwahati High Court Bar Association, which can enforce the order.
This matter become infructuous.
Upon instructions, Mr. K. Barua, counsel for the petitioner, submits that the matter has become infructuous. Accordingly, this matter stands dismissed on having rendered infructuous. Standing, Ms.
A. Chakraborty
A.
for all
Chakraborty,
respondents.
stand, on behalf of standing counsel for FCI is present.
Item number 2 for admission.
Item 2 and 3 are analogous matters.
Yes.
Both pertains to non-payment of contractual dues. Lordship would take up item 2 for a moment. The affidavit has been filed. I'll just take your lordship very briefly. The documents, my lord. Well, directly come to page 19, my lords.
No, there has been a foreclosure of your contract.
My lords.
That means your whatever payments are due to, whether it's there or forfeited.
Sorry, my lords.
There has been a foreclosure of contract.
Foreclosure, my lord, but I have already completed the work and they have admitted, my lord, they have paid half of the amount, more than half of the amount.
Where is that?
My lord, lordship would find that in their affidavit. My lord, page 30, my lords. Their affidavit.
In page 30, they say that it's a non-gender for Union of India.
I don't have any privity of contract with the government of India, my lord.
No.
The work was allotted by the state of Assam. The executive engineer gave me the work completion
Okay,
order.
how much amount is due?
My lord, according to us, my lords, there's an annexure, my lords, the last annexure F, page 25, 14,91,000, my lords. Page 25 of the writ petition.
1491.
Yes. My lords, in fact, there's an order authored by my lords, my lord, wherein, my lord, when a stand was taken that there was no funds, lordship had passed an order. Even in this affidavit also, they have taken 3 grounds, my lord. First, that there are no funds.
Yes. You're there?
But they should have Karbi Angle Autonomous Council. They will have to reply.
But within 3 months, they'll pay.
Mala?
Within 3 months, they will pay.
Lots.
Outer limit of 3 months. Heard. Mr. P. Mahathir and counsel to the
Only
petition.
she will indicate that they will verify the claim. And
Verify,
whatever is due,
verify.
that will be.
In the affidavit, they have already admitted,
Well, that part.
but we'll still say that. We'll still say that.
Right.
Mr. P. Mahathir, counsel to the petitioner. Mr. Also heard Mr. B. Goel and standing counsel for the PWD.
For respondent number
Representing-
3, madam.
Respondent number 1 also,
Yes, madam. 1 and 3.
1 and 3. None appears on call for the Caribbean Autonomous Council representing respondent number 2, 4, 5 and 6. The petitioner claims to have completed the contract work of improvement of capital BBDC road from CH full stop 19700.00 M PO2 207000.00 M under NLCPR for the year 2008-9 during work order number capital ACEH oblique CS
My lord,
oblique, you are there,
my lord.
oblique NLCPR
It is not admitted
Oblique-
amount, my lord. It is not admitted amount.
oblique 48 oblique 2009-10 oblique 4 capital A.
Consider my written argument.
Mrs.
And this is the
Shukla.
document of the Supreme Court. And this is a matter of central government project, my lord, in order of India. And as per the terms and agreement condition, my lord, it is required to be completed within the 2 years, my lord. And that scheme has been foreclosed, my lord. Work order was allotted to the another person. And they have completed the work. They did not complete the work. Let
No,
my
but
learned
where
friend,
where have you denied that they have not done the work?
my lord. We have filed the affidavit, my lord.
Where is that stated?
And lordship will look into my written argument, everything is there, my lord.
Written
In the
argument will come.
affidavit also there, my lord.
Show me that.
Lordship will take up the 1987/2022 petition. 84, referring to the other. item number
1984.
3. Lordship will look into my lord, paragraph 4 of my affidavit.
Yes.
That the Ministry of Development of Northeastern Region, Government of India provided the central government assistance under non-lapsable central pool of resources for the project improvement of road at 30 kilometers so and so. The project estimate was that so and so, and the Government of India has granted financial approval of rupees so and so, and the state share was so and so. The approval of Ministry of was subject to the condition that the Ministry of Government will release 90% of the project costs as a grant of installments, and the state government paid a balance 20% of loan of component to be so and so. The time frame for completion of the project was 24 months. And date of sanction letter is 16/6/2009. Would be reckoned as the date of start of the project.
target date of completion of the project was June 2011, and the time frame was required to be followed strictly. And they have not completed the project, my lord. Central government did not release the fund. That is the next paragraph. Then, my lord, paragraph 6, that we have
No, no.
stated the petitioner did not complete the
Mr.
work.
Sudhir, I will not be able to follow you for a different reason. You see, from the contract, you'll have to show me that if he does not do the work within the time frame, he loses his money.
My lord, we have, lordship, we have, and my lord, we have written that also, my lord. That is in my written argument is there.
Argument will not do. You can't improve an agreement from an argument.
Paragraph 8 of the affidavit.
No, no, you show from the agreement first.
Then lordship may fix it on that, we will produce a record also, my lord.
Because you see, Mr. Sudhir,
My lord.
for the only question is that number one, you have to demonstrate that if the work does not done,
My
then
lord.
he loses his money.
My
Number two, if the work is foreclosed,
My lord.
then also he loses his money.
My lord.
And any input given
My
during the tenure of the agreement
My lord.
is lost. Number two, third, there is a judgment of the Supreme Court of India in 1996,
My lord.
1976. Citation I will not remember immediately. It says that for a construction contract,
My lord.
time is not the essence of contract.
My lord. That my judgment, my lord, 2021 judgment, I have produced before your lordship. In this matter relates to the contract work, my lord. And that is if they are not working the work and there is a dispute, my lord, then what is the remedy available to that is dealt with by this particular judgment.
No, but dispute I don't find. Your
My lord,
affidavit I have read.
My lord, we have filed in the affidavit, we have specifically stated, we have cancelled the order. As they did not complete the work, we have cancelled the order.
Look at the-
With all
look at
due
that
respect,
letter.
my lord, that's a
My
blatant
lordship,
lie,
look
my
into
lord.
our affidavit, my
Look
lord.
at that
I'll show, my
letter.
lord. Let him
Look at that
complete, my lord.
letter.
My lord,
He's
Look at that
submitting
letter.
beyond the affidavit, my lord.
Show us that letter.
my lord, lordship, 1987, lordship, look into 1987 first.
Yeah, 1 minute, 2 minutes.
This is same contract or different contract?
The person is the same, my lord, fund is different, but the owner is the same, my lord.
No, no, owner will be same, but since I am looking at
My
the
lord,
first
Lordship, annexer to page 47,
of second item,
second
item
item,
two,
my lord, 1987. I have prepared for that one, my lord, for today.
page
Page 47.
7.
My lord, fact is that, my lord, there's a particular work that was allotted to the different contractors. The petitioner was allotted, my lord, 13 works. The main work, my lord, regarding the construction of the road, he has not completed. He has not did that. He has
I'm
worked,
not
my lord,
claiming, my lord, that word. I'm
My
not
lord,
claiming.
if the my lord lordship wants to dispose of, lordship may fix it. I'll
No, no,
put
it's
the
not a
record
question of
also.
disposal. Every case I am disposing it off.
My
The
lord,
matter is listed in the board, I am disposing it
my
off.
lord, lordship,
I can
look at
dispose it.
annexer to page 47.
Mr. Sudhir, I don't need anyone's approval
My
to
lord,
dispose of a matter in a motion stage,
my lord,
at the admission stage,
my lord.
at
No,
the
I'm
order
not-
stage,
I'm not on
or
that.
at
It
the
is
hearing
that-
stage.
My lord, it is not that.
Huh.
But if the councils are submitting in the otherwise like that.
No,
way,
that's okay. I am
only the
restraining
record.
him.
My lord,
I am restraining him. Why
My
should you take an offense?
no, my lord,
In
it
the
happens
court,
well
I am-
earlier also. It
No, no, in
happens
the-
earlier also. If it happens regularly,
No,
my
no,
lord,
no. You
he
see,
will feel disturbed, my lord.
at least in my
It is,
courtroom,
my
I can
lord.
say,
Yes,
I'll take control over the affairs. The council need not take the trouble of.
but it happens while earlier in this
No, no,
particular
it's
case. So
okay.
I'm pointing out.
You leave it to me to take
My lord.
control of the court,
Lordship,
of the
look at
court
the annexer
affairs.
to page 47,
Because disharmony in the court, I don't appreciate.
my lord,
I start my day with a smile.
my lord.
I try to end my day at
With
5
my
o'clock
lord,
with a smile.
my lord, it is for
Correct.
us also, my lord. If you can do that also, my lord.
Uh,
But sometimes we could not do that, my lord. That is our difficulty, my lord.
No,
Lordship,
that is
look
okay.
at the annexer to page 47,
That is okay.
my lord,
Then you see, then there's only one suggestion.
my lord,
Go and start learning either karate or kung fu.
my lord.
In karate and kung fu, your first lessons are to control your mind.
My lord. Yes, my lord. Yes, my lord. But
And-
sometimes, my lord, if
and,
the personal attack is there,
no,
my
no,
lord, then
and- no,
we
no,
can lose the
and
matter
second
control
thing
sometimes, my
is,
lord. That is a
once
difficult,
we know that you are a black belt in karate,
my
I
lord.
don't think anybody will shout at you.
My lord. Lordship, look at annexer to page 47,
47, yes.
my lord. There is a 28th September 2008 cancellation notice. Improvement of BBTC road from 1st to 30 under the so. These are all the, my lord, letters from 10 to 2020. It is
I've seen
noted
this,
with great.
this letter. Don't worry. I've seen this letter. Here you have said risk and cost.
My lord.
Correct. And now you have not shown anything that the risk and cost was imposed and he was you asked him to make payment of that risk and cost.
My lord, what happened, my lord, in this particular case, it is a central government project. After
No, no,
foreclosure,
that is
central
okay.
government did not
Mr.
release
you-
the fund. It is
Mr.
our
Sutia,
difficulty, my lord.
Mr.
We are
Sutia,
not disputing that,
I'm not,
in the first case,
I'm
he
not
has
questioning-
completed the work after the,
Mr. Sutia, I'm not questioning whatever you are saying.
my lord,
What I'm saying is that if you don't want to pay X,
my lord,
I forget Mr. Mohanta for the
My
time
lord.
being. You don't want to pay X,
my lord,
then you must demonstrate from your stand that A is not entitled to the money for X, Y, Z and reasons.
my lord.
Correct.
My lord,
Now, let us say the tone and tenor of this letter,
my lord,
I don't find your action to be, your conduct to be good.
my lord, but,
I'm just saying,
Yes,
here,
ma'am,
it
my
is
lord.
written here.
my lord.
I'm not telling you.
My lord, my lord, my lord.
I'm not
No,
telling
it is
you.
not my person. It is the, what is the department says. My lord,
No,
what
that is
the-
okay,
I'm
but
submitting
no, no,
about
what is
what
okay.
my lord.
You
It
see,
is not my personal.
no, no.
capacity.
That's what I'm saying.
Mm.
Here it is written that your conduct is not good, so
Mm.
therefore cancel your contract, risk and cost imposed.
My lord,
Now, in order to deny payment to someone,
my lord,
is it not required that you should show something more?
my lord.
Then,
My lord, we have shown that it is a central government project as the did not complete within the 24 months. The central government, my lord, did not release any amount. If the central government did not release amount, Union of India should be a party in this particular case. So without the Union of India, without making a respondent, my lord, and it is a central government project, they are not releasing the amount. How the state government or the state or the council will make the payment, my lord. That is the point for consideration. For your consideration, Lordship may consider it that point, my lord. And without Union of India, the reason for foreclosure of the project,
you produce that agreement.
my lord.
You
We
see,
have
because
mentioned,
without a document, I won't
my
understand
lord, we
anything.
have in the affidavit, we have stipulated the conditions, my lord. What is the conditions is there?
Since I come from the wrong side of the board. Because if there is an agreement, I'll read the agreement. Because the agreement, according to me, is the section 92 of Evidence Act.
My lord.
That will override any other.
We
Any
have
other,
stated in paragraph 8, my lord, regarding the condition of the clause.
no, no. You see, once there is a document, I'll have to read the document itself.
My lord, my lord, my lord,
I'm not shying out. It's
My
not
lord,
a
my-
shortcut for me
my lord, my
that I read paragraph 8 and record my satisfaction.
my lord,
The issue is that if you say something based on record,
My lord.
I'll take it.
in the affidavit, we have stated that, but that is so we have prepared a written argument on that, my lord.
It's okay.
My lord.
Now let's- First, my sincere apologies.
No, let me,
to my
let me,
learned
let me,
friend
no,
also.
no, let the record be produced. If I'm not hearing it, I'm not
Yeah.
spending
But one-
any
just
more
one
time.
clarification, my lord, my learned friend has referred to a letter, my lord, 47. My lord,
You
may
be
kindly have
prepared
a
on the
look
next
once.
date. No, no.
I'm not
If
claiming for that project,
you see, once I'm not disposing it off,
my lord.
I'm giving them time, so I'm not putting any other effort.
My lord, that effort, with all due respect, may not be required because the perspective, he may be, my lord, but just for a moment, one moment. My lord.
You
Page
see,
47.
number one, if a issue of document has come, he's ready to reproduce the records. Let me see the records. Correct. If I'm not disposing it off, I'm not spending any time.
My apologies. my lord.
Both, all sides, Hudson, say. In view of the stand taken in the affidavit in opposition, Mr. J. Sutia, and standing counsel for KAAC, and has expressed his desire to produce the records. The player is allowed. List on.
But 2 weeks. It is from Borpatha.
Tell me the time. Tell me a
Any
date.
date, my lord, Lordship, after 2 weeks, any date.
Your calendar is in the front.
Third August.
Hmm?
3rd August,
3rd August 2023.
Deeply obliged.
second,
Just a moment, just a moment.
2nd August.
No, no. 2nd August.
Deeply obliged.
But there's a division bench on that day. There's a division bench on that day.
Oh, my lord,
Third.
then,
No, no, second we are taking it up. Third. This both the items. You give a copy to Mr. Mahanta also, this written
Written argument.
synopsis,
my lord.
the copy of written argument and case citation of 2021 10 SCC 690 produced by the learned standing counsel for the following not sponsored is retained in record.
In this case, in cases, item number 5.
Yes, how's your
If
son?
there-
Somebody told me that you had gone for your medical treatment of him.
Yes.
How is he?
He's okay, my lord. The last, in the month of May, he was operated, so he was called for a checkup, my lord. It was okay. And what I pray, my lord, that item number 5 may be taken up first, my lord, because therein, my lord, the stone crusher regulation is under attack, my lord. 5.5. That will be 1357 of 2015.
Oh, well, that may be taken up, ABCI, that may be taken up along with item number 7, my lord.
Yes.
First,
Every-
your lordship must take up 4 and 6, my lord.
my lord, for
Let him do it because we are taking up together.
Yes.
Let him be happy with
Yes.
item number.
Five, will- five,
Five
my-
first.
5 deals with everything, my lord.
Well, I am the petitioner, my lord.
It's
I
okay,
just press it.
but additional advocate general says that 5 be taken up first. We'll take it up. Same thing for you.
My lord.
You have prepared something else.
No, my lord, serially I wanted to go, my lord.
Okay, you
Because
do it in
both
on
will
way. You do it on
Yes.
your way.
4 may be taken up first, my lord,
It's okay.
because that will also come, my lord.
Okay. Yes,
My lord, the petitioner, my lord, he is a stone crusher and he is
just a moment.
purchasing the holders, my lord, minor minerals from the miners. My lord, may directly come to page 51, my lord. For the petition.
$51.
51, series, the series. Now, these are the miners has issued. Minor is the, my lord, Indra Subba. Left hand column, you will also see consignor, minor mineral concession area, holder, contractor. Indra Subba, number 2, Diligat, Gaon, Namrup, so and so. And right hand column, my lord, are seeing the petitioner. He has purchased the, my lord, the stone materials, my lord, from him, my lord. There are about 5, 6, my lord,
Just first of all, where is that notice you want to be quashed?
my lord, yes. That item. That, my lord, your lordship will find, my lord. Annexure 10 page 62, my lord.
Page 62.
First one is this, my lord. This is first one, my lord, then second another. You are hereby call upon to produce legality and proof of origin of first produce as per provisions of the rules and regulations having the force of law loaded in track number so and so. Major ordinance rules so and so, so and so, so and so. The first notice has been issued, my lord, as per the first rules. Now, later on, my lord, they have changed it. 2 tracks are involved. I am not placing the second track. Now your losses may come to page 66.
Page
Page 66.
66.
66. 66 and 67, 2 notices are there for 2 tracks. Mal.
Yes.
Here your losses find vehicle seizure penalty ticket. My lord, your loss will find price of minor mineral
Yes,
Here, offense type, my lord, that is also important. Minor mineral illegal transport.
yes,
Illegal transport. Then, my lord, they say price of minor mineral 10,200, royalty 1,700, GST 595, income tax 303, fine amount 50,000, then processing fee 310. So from one track, they are asking for 63,108. So this is the main crux, my lord, because earlier notice was issued, that is, they have given a go by on sales. Second one, page 67, similar, my lord, for another track. This is, they are demanding 66,000.
yes.
Now, I have already placed my lord 51 in the series. My lord, 6 documents I have just to that 51 to 56. These are the 6 documents. These are the indeed, my lord, issued at the by the minor. Petitioner. So
This is transit pass.
these are transit pass, because transit pass is only required at one time, my lord. At the time of removal from the mines, not otherwise. So far minor minerals are concerned, my lord, not otherwise. Just like in forest, my lord, subsequent transit passes are not required.
But from your documents here, this documents you are referring to page 66,
Yes,
62, 64, 66, 67.
my lord.
How do I find that this, from where this consignment was from, it was traveling from which place to which place?
That I am placing, my lord, page 57.
57.
Yes. From my lord, stone casa unit, I am sending it, my lord.
57.
Yes, 57, 58. 2 trucks, my lord. These are the, my lord, tax invoice. I have
Yes.
my lord. Because, my lord, these 2 trucks were illegally, my lord, restrained by the forest authorities. At page 59, we have submitted an application also. Page 59 and 62 applications.
Yes.
Thereafter, my lord, that page 62 notice has been issued regarding forest produce, but later on, my lord, they have issued this penalty ticket. This is the case, my lord. That affidavit has been filed, my lord, in this regard, my lord. And if your lordships, my lord, affidavit, no question is into para 5, my lord.
Just a moment. Assam Forest Rules Assessment. It will forest manual. Just a moment.
Yes. Assam forest regulation, my lord. Just
No, I'm just trying to find out the provision for Charan.
provision for Chalan, my lord, your lordship is to see in respect of minerals. I shall place the Supreme Court judgment, my lord, on this point.
No, this transit pass or transit Charan, there's a provision in the act.
They are in the Forest Act, my lord.
Forest Act, that's
Forest
right.
Act, but this is not a forest produce, my lord. This is not a forest produce, this is a minor mineral.
Oh, acha. Okay. Okay, okay.
And your losses, may that is why I want to, my lord, refer to para 5 of the affidavit motion.
Para 5 affidavit in opposition. Yes.
My lord, stone crusher unit Assam governed by so and so. My lord, that case will come later on, without obtaining a permit from the government, the forest department, so and so, so and so. Then last sentence, the main stakeholder in the context department of forest, since stone is a minor mineral under the Assam minor mineral concession rules. And now the penalty ticket has been issued as per the minor mineral concession rules. My lord. I shall place there also. Minor mineral concession. My lord, your losses has got this book, my lord. Here, minor mineral concession rules is there.
No.
Otherwise, I have to give the copy, my lord. Copy. I'm giving a copy.
Minor mineral concession rules.
Right.
Concession rules I have. They've given it to me. itu actually legible lagi kita macam. Itu kita pernah
My lord,
question buku
rule
tadi
3 maybe.
kita masih. Apa lagi?
Rule 3, my lord.
Rule 3. Yes.
A mining lease or a mining contract or permit or any other concession or license or transit pass or permit or license or control of regulation of mining other than actions under these rules shall be granted taken by the director in respect of minor minerals for industrial and specific uses specified in Civil Acts, Principal Chief Conservator of Forest and Head of the Forest Assam, or by any other officers, government of Assam by notification in this behalf in respect of minor minerals for the use other than industry. So and so. Now, if you're this Y, my lord, stone comes under Y, so forest department has the right. Now, if your losses come, my lord, if your losses, see, my lord, that rule 63, my lord. Is chapter 12, my lord. Chapter 12 is in respect of, my lord, illegal or unauthorized mining and consequences.
$66.
my lord.
Which provision you said? 66,
63, 64, 65, my lord.
63. Okay.
Yes, 63. Illegal unauthorized mining. They have, my lord, virtually applied this provision for the purpose of penalty ticket. 64(1), my lord, if you will also see, act of illegal unauthorized mining shall be liable to the following for first time violation. As the said materials will be liable to seize along with the compounding tools, equipment, vehicles, things used for such person, which may be released upon realization of the payment of price of the mineral, applicable royalty for the mineral extracted. In addition to fine, shall not be less than 10,000 rupees. This is the budget. So first thing, my lord, it must be illegal. Because I shall place the Central Act, my lord. It will also see, my lord, Central Act, my lord. My lord may see section 3E of the minor mineral development regulation. It is minor minerals means the building stones, gravel, ordinary clay, ordinary sand, other than sand used for the prescribed purposes or any other mineral which central government may by notification in the official gazette declare to a minor mineral. I shall place the list of the minor mineral also, my lord, declared by the central government. Now your losses may come to section 15, my lord.
Section
Section 15.
15.
This is the rule making power, my lord. Because so far minor minerals are concerned, my lord, state government can make the rules. Major minerals, my lord, some minor minerals have been taken away now, my lord, I shall place that also, because in the fourth schedule, some minor minerals have been taken away because these are national importance, just like, my lord, the limestone and bauxite and other things, only because saying that it's a notified mineral. And for that, my lord, some guidelines will be issued by the central government, but these are minor minerals. Now, power of the state government to make rule in respect of minor minerals. The state government may by notification of official gazette make rules for regulating the grant of quarry leases, mining leases, my lord, that we are proceeding, or other mineral concessions in respect of minor minerals and for the purpose connected therewith. So this is only in respect of, my lord, settlement of the queries, not in respect of any other. One A also, my lord, giving details, everything is only for this purpose, not for other things. Now, my lord, in 72, 3 new sections were added, that is 23A, B and C, my lord.
Which provision?
23A, capital A, B, C. A, B is not so much necessary, my lord, because rule making power is under 23C, my lord, state government. You'll also got 23C, my lord. Yes. Power of the state government to make rules for preventing illegal mining, transportation and storage minerals. The state government may by notification in the official gazette make rules for preventing illegal mining, transportation and storage of minerals and for the purpose connected there. So it is in respect of illegal mining. If illegal mining is there, then state government can make rules. That part I have already placed sections rules 63, 64, 65, that is for illegal mining. Nothing more than that. And this has been interpreted by the Supreme Court in a judgment. That judgment I want to place,
Ordinary citizens will not understand.
My lord.
You see, my idea is,
Yes.
no, and speaking to Mr. Goswami,
Oh.
my idea is, I may be horribly wrong. But what happens is that people who are doing mining, you don't want to touch. But you are standing outside when the truck comes, you seize them.
Yes.
Because miners know.
No, I understand. But I understand. But this is the general perception I am having. I may be horribly wrong.
Well,
Every likelihood that I am wrong.
Sometimes, all the materials were not placed before the process, it left. So I am placing one judgment that is very important. In 2019, SCC 513.
Because the only thing I see when I travel in the road is that sand trucks. I see nothing else.
In fact, both in excise and forest department earlier, against one transit pass, Salan, 7, 8, 9, 10 trucks were transported.
Not 10,
That's
it may
why
be
the
100.
government was losing revenue.
Not 10, it may be 100.
Now we have made everything online, man. That's why Malad has seen excise
No, but
revenue.
the actual amendment which you have to make, you don't make that. Because you don't want things to be serialized. The department doesn't want things to be serialized. Either they are just like me, wearing a spectacle, can't see beyond what I'm supposed to see. Second is that they don't want things to be serialized. You see, what is the why don't a simple amendment be made in the in your act or rules and say that this transit pass will be accompanied with all the vehicles, because you see this transit pass is issued from the mining lease to the dump yard. In this case, you may have noticed the Chalan is that transit pass is from the mining area to Namru.
Yes, sir.
The petitioner, the invoice which is saying at page 57 is originated from Namru. So if a truck is carrying a consignment note, he's not required to have that what you call the transit pass with him. Because you see, everything is quantified. Number one, you are aware that how many metric tons of forest mining products have been released. You can have it that you have a truck, it has a capacity, and you know the capacity, or a dumper, you know the capacity of the dumper. So each quantified amount of mineral which is passing through shall carry the transit pass all throughout, just like a wood.
Yes.
Then everything is in serial order.
In fact, there is stone crusher regulation, madam. That is why I was praying for taking up item number 5. That
It's okay.
regulation is under challenge. That regulation specifically provides for transit pass. Even Assam Forest regulations of 1891 also speaks about that regulation 40, this transit chalan and transit pass.
When you educate people, you tell them that under the forest act you have to do it, but that you are not doing. It was only in the last occasion when Mr. Digogo was making an argument, I came to know for the first time. So you see, even for me, it was the first time I came to know that under the forest regulation, you are still following the forest regulation also.
Yes.
When the principal act has been amended, these minor minerals have been amended, schedule has been altered, and then you go back to your.
But that Kumar judgment says we have parallel powers under forest regulations as well as MMDR Act.
Tomorrow judgment I shall place, my lord.
No, it's
Because
okay, but
1 or 2 paragraphs, my lord, that is very important.
but if you make it mandatory in the transit pass rules, you don't have that.
Yes.
Then it should be carried. So therefore, things are multiplying. When yesterday I said, it's just like somebody carrying and traveling in an aircraft. There is every possibility that 100 passengers will fly in the aircraft and 101 passengers may come down.
My lord, these amendments I have given, my lord, and the central government, my lord, why they have amended 3 times, my lord, 2015, 2020, 2021. All the amendments I have given, objection reasons I have
No, but
given.
an issue will arise if you are prepared to answer that also.
Yes,
You see, the issue which now Mr. Goswami is raising. Additional education generally is saying that the residuary powers under which they are doing is under the forest regulation. Now an issue will arise. Firstly, that number one, that forest regulation is a pre-independence act. So it is said by Article 272. So if that power is there, the notwithstanding the amendment in the mines and mineral development and the curtailing of few items in the schedule, still if that forest regulation is saved, you are still trapped.
no, my lord, that cannot be, my lord, so far minerals are concerned. That is why I am placing this.
No, you see that schedule, the Forest Act.
First, my
You
lord,
you have that.
I shall place one, my lord.
Huh.
My lord, because why I am placing Forest Act also, my lord, say 2 categories. If your lordship just may see, my lord, section
No, you make your own presentation. I'm just telling
Section
you,
3,
this
4, my lord,
this
just-
point will come up.
yes, all.
You go as per your preparation.
My lord, your lordship
This
may
will
just
come up.
take up this judgment, my lord, 2019, 16 SCC 513.
Yes.
My lord, here, my lord, at para 7, my lord, they have quoted the rule section 15. My lord, page is not there, my lord, I'm sorry. My lord. And here, my lord, they have given the objection reasons also for my lord, this. Now, I am not placing that much also. Then for 1A, my lord, they have quoted section 23. Now, para 9, my lord, your lordship is.
Just now, man. Para 9.
Para 9. As noted above, the impugned rules are made in exercise of powers conferred under section 23C of the MDR. Further, as per section 14 category states that provision of section 5 to 13 are not applicable in respect of minor minerals. Rulemaking power of the central government contained in section 13 does not extend to minor minerals. It is in this context, section 15 gives power to a state government to make rules in respect of minor minerals. The state government thus is given power under section 15. It is also given power under section 23C. A perusal of section 15 and 23C in relation to aforesaid discussion would clearly suggest that power of the state government to make rules is restricted to 1. Making rules for grant of quarry leases, mining leases, and other mineral concessions in respect of minor minerals and for purposes connected therewith. 2. Making rules for preventing illegal mining. My lord. This is 23C, my lord. Transportation and storage of minerals and for the purposes connected therewith. In the aforesaid context, the question arose to the High Court as to whether, in exercise of powers delegated by the legislature upon the state government, would the state government make a rule to the effect that the sand, which is a minor mineral, would not be allowed to be taken beyond the borders of the state of Gujarat, and making such movement as punishable offense. Which a minor mineral would not be allowed to be taken beyond the borders of the state of Gujarat, and making such movement a punishable offense. According to the High Court, delegation of the powers to the state government under the aforesaid provision does not include or envisage restriction on interstate trade, commerce, and intercourse, which will shall be free. Thus, the impugned rules are held to be altered by the provision of section 1523 of the MDR. Now, my lord, I shall place the paragraph, my lord. (34), my lord, your lordship may just come in. Paragraph 34. The question will be decided, my lord, there. Whether impugned rules framed by the state of Gujarat as delegate, delegate of parliament are beyond the powers granted under the
Mr. just a moment. Just a moment. Yes.
Now, para 34, my lord. You see the, that's why this judgment is given.
Para 34.
Is
Yes.
from the subject matter of these appeals as well arguments quoted above, it clearly follows that main issue arise for constitutional standards. Whether the imperial rules framed by the state of Gujarat as delegate of the parliament are beyond the powers granted and to it under the MPR Act. In other words, whether imperial rules are ultra virus to section 15, 15A, 23C of the MPR. Whether imperial rules are violative of part 13 of the Constitution of India. The appellants have submitted that section 15 gives power. Subsection 1, section 15 empowers the state government to make rules for regulating grant of quarry leases, mining leases, and other concessions in respect of minor minerals and for the purposes connected therein. This power of regulation pertains to granting of leases. It is the submission of the Mr. Kapoor that expression regulating is widest amplitude and would therefore confer power to make rules of the nature made therein. He has referred to various judgments of this court wherein expression regulating has been explained. He has also submitted in that in case of section 15(1)(a). Such a power is there and this provision has to be read independent of section 15(1). It is difficult to accept the aforesaid contention in view of the judgments of this court in MPP, Kaveri Society and DPKT Bhage. In those judgments, it has been categorically held that power of the state government under section 15 of the MDMA does not include control over the minor minerals after they are excavated. The following observations from the said judgment are extracted here. The High Court quashed Rule 8D and 19B principally on the ground that section 15 of the Act gives no power to a state government to frame rules to regulate internal or foreign trade in granite after it has been quarried. Section 15 also did not empower the state government to frame rules to enable the state government to company or a corporation fix a minimum price for the granite. The learned counsel for the appellant state submitted that Rule 8D and 19B were valid having regard to the preamble the said Act, and 18 thereof he submitted that rulemaking power of the state under section 15 was wide enough to encompass Rule 8D and 19B. The said Act is enacted to provide for regulation of mines and development of minerals under the control of the Union. Subsection 2 of the said Act declares that the expedient in public interest that Union should take up under its control the regulation of mines and development of minerals to the extent provided in the said Act. Section 13 empowers the central government to make rules for regulating the grant of prospecting license and mineral leases in respect of minerals and for purposes connected therewith. Subsection 1, section 15 empowers the state government to make rules for regulating the grant of quarry leases, mining leases, and other mineral concessions in respect of minor minerals and for the purposes connected therewith. Subsection 1A of section 15 states that such rules may provide for the matters set out therein, namely the person whom and the manner in which the application for a quarry lease, mining lease, and the like may be made, fees to be paid thereof for time and the form in which application is to be made, the matters which are to be considered, which where applications in respect of the same land are received on the same day, the terms and conditions on which leases will be granted or regulated, the procedure in this behalf, the facilities to be afforded to the leaseholders, the fixation of collection of rent and other charges, and the time within which they are payable, the protection of rights of the third party, the protection of flora, and the manner in which leases will be transferred, the construction, maintenance, and use of the roads, power of transmission lines, etc. on the land, the form of registers to be maintained, reports and statements to be submitted, and to whom, and the revision of any order passed by any authority under the said rules. Clause A of subsection 1A reads that any other matter which is to be may be prescribed. Rule 18 of the said Act states that it shall be duty of the central government to take all such steps as may be necessary for conservation and systematic development of the environment by preventing any pollution which may be caused by the prospecting or mining operations. Rule 8D and 19B empowers the state government or its officers of the state government, company or corporation of the state government may direct to control the sale by every permit holder of the quarried granite or other rock suitable for ornamental and decorative purpose. They also empower the state government or officers of the state government company or corporation, as the case may be, fix minimum price for the sale thereof. The object is shown terms of the government order number so and so quoted above is to conserve and protect granite resources. It is difficult to see how granite resources can be protected, controlling the sale of granite after its excavation and fixing minimum price thereof. There is no power conferred upon the state government under the said act to exercise control over minor minerals after they have been excavated. My lord, this is very important. My lord. Once it is excavated, my lord, there is no power on the state government if it is legally extracted. The power of the state government as subordinate rulemaking authority is restricted in the manner set out in section 15. The power to control and sell price of the minor mineral is not covered by the terms of the clause O of subsection 1A of section 15. This clause can relate only to the regulation of the grant of query and mining leases and other mineral concessions, and it does not confer the power to regulate the sale of already mined minerals. Likewise, the condition of license granted by the state of Kerala to the effect that it could be sold only within the state, that too for domestic and agricultural purposes, was struck down in the following words. The appellant's complainant is certain conditions in the form of restriction have been incorporated while issuing the licenses. One of such conditions which the appellants attack is that minerals permitted to be staked were to be purchased only from the authorized query permit holders on their behalf. Another condition is that they are permitted to sell the minerals only within the state of Kerala, that too for domestic and agricultural purposes. The appellant's complainant is that as far as the cooperative society are concerned, they are not saddled with any such restrictions imposed in the case of the appellants. Thus, according to appellants, there is a clear discrimination between the cooperative society and individuals in the matter of restrictions imposed in the license granted to them. Apart from that, there is no legal sanction for such restrictions. Now, my lord, I shall come to paragraph 40 to 43, my lord. I shall not bother your losses, my lord, to this. Paragraph 42. Next page.
40 to 43.
Yes.
Yes.
On the other hand, the prohibition on the transport or sale of already mined mineral outside the state has no direct nexus with the object and purpose of the MDR Act, which is concerned with the conservation and prudent exploitation of mineral. So, my lord, it can be sold anywhere, my lord, outside the state also. In so far as section 23C of the MDR Act concerned, it was inserted in 1999 Amendment Act with the objective to prevent illegal mining. Well, this is very important. That is clearly spelled out from the statement of objection. Just we may have reproduced a portion thereof. A few provisions is proposed to be inserted in the Act prohibiting transportation or storage of anything causing transportation or storage of any mineral except under due provisions of the Act with a view to preventing illegal mining. Further, Act is proposed to be amended to cover breach of provisions of the proposed new provision of the Act to be punishable. It is also proposed to insert new provision to provide anything seized under the Act as liable for confiscation in the court orders. A new section is provided inserted to empower the state government to make rules for preventing illegal mining, transportation, storage of minerals, and for the purposes connected there. So this is 23C, my lord. I have already placed, my lord. 23C has been, my lord, only for illegal mining. It is in this context the word transportation and storage in section 23C are to be interpreted. My lord, this 42 para. Here, two words are used in context of illegal mining. It is clear that it is the transportation and storage of illegal mining and not the mining of minor minerals like sand, which is legal and backed by duly granted license, which can be regulated under this provision. Therefore, no power flows from the provision to make rules for regulating transportation of legally excavated minerals. This was clearly said, my lord, there is no power, my lord, to the state government. As far as issue B is concerned, we are also consider opinion that impugn rules highlight part 13 of the Constitution to effect thereof to better the freedom of trade, commerce, intercourse under section 301 of the Constitution. Under this article, the expression freedom must be read with expression for the territory of India. Under Article 302, Parliament may impose restriction on the freedom of trade, commerce, or intercourse between one state and another that may require public interest. This is not so much important so far this case is concerned, but the Supreme Court has held, my lord, that Interstate sale also cannot be restricted by fingerprints. This is the, my lord, my full submission, my lord, this,
Interstate,
Judgment
it
has-
also says foreign trade.
yes, pointed also. My lord, there is no restriction, my lord. So in this case, my lord, what happened, my lord? I have already said, my lord, that I have purchased the mineral from the miner. I have crushed the materials and thereafter I have issued the challans, my lord, tax challans, and send it to the destination, my lord. During the, my lord, transit, my lord, they have intercepted it, saying that it's a illegal material, illegal material. And now they have issued this, my lord, penalty tickets. My lord, my humble submission that, my lord, this is absolutely illegal. These forest officials cannot do that, my lord, because since the petitioner is purchasing the stone materials legally from the miners. So such the rule 63, 64 does not apply in this case. 64. Well, they have applied 64, which will not apply in this case. So for the other part, my lord, I shall come in the next case, my lord, that crossing limitation. Huh? So far, my lord, this my,
But you
my
know,
lord,
ultimately,
is
Mr.
concerned,
Saiwala,
my lord,
ultimately, you know, of all senses, there's one sense which is called visual
yes,
sense. And when you travel on the road, then you understand the amount of sand being carried, the amount of stones being carried.
it's correct, my lord.
If you travel by air, before you just enter the SGP airport
That is Rani
Rani area, then you find that the entire hill is vanishing.
My lord,
The
they have to take
pace is astounding.
they have to make inspection in the queries, my lord. first.
That I told you
Because
that they don't want to do.
MMDR Act, my lord, does not empower, my lord, the transportation, my lord, to be called, my lord. That cannot be done, my lord, unless it is illegal mining. And what, my lord, Forest Act says, my lord, the losses may just
That
be
nobody wants to do. That police inspector who was crushed by the by that dumper,
yes.
I think nothing has happened.
In fact, my lord, my experience, my lord, first then experience in the Tulsi River, my lord, in the name of protecting dolphins, 5-6 petitions are being filed just to prevent us from going for regular tender, my lord. Then they will do it mechanized illegal mining. There are a law and order situation also. My lord, here in this petition also, my lord, in the name of, my lord, basically the petitioners who are indulging in illegal mining, illegal transportation.
So far dolphin
Once
is
an
concerned,
endorsement for me, lordship, that
so far dolphin is concerned, I had to read and then by the time the arguments were over, I was what you call, I had superficial knowledge of dolphins. This is one of the cases I've dealt with.
Yes.
So I'm aware.
There are 4 or 5 cases pending since 2018-19, my lord. There are interim orders operating, my lord. And therein also, my lord, only plea to save the dolphin, they are filing this case.
No, but why do you catch the truck driver? You don't go to the source. That's all.
No, well, I think, my lord, because so far that I want to place that mine, my lord, your losses may just see first produce in definition 3, section 3, subsection 4 in a Forest Act, my lord. Huh?
Forest.
Rahul das that no, you're taking to record it. Hello, subsection 4, section 3.
Yes.
forest produce includes the following whether found in or brought from forest or not. That is to say timber, charcoal, the ketchup, wood, oil, resin, natural varnish, so and so, so and so. Well, these are the items which are first produce, whether they are found in forest or not. But later, my lord, you'll also see B is different. The following when found in brought from forest, that is to say trees and leaves, fruits, so and so, so and so, so and so, my lord. The last one 4, my lord, see peat, surface soil, rock and minerals, including limestone, laterite, so and so. So the Kumar judgment, my lord, in paragraph 110 and 7, my lord, it was considered that method, my lord, because that step, my lord, earlier, because that has to say that if it comes from forest, here, my lord, they have settled the query under minor mineral concession rule. And the Mahaldar, my lord, issued the transit pass to us. It is a minor mineral, it is not a first. And that is why, my lord, initially, although they have issued the notice under Forest Act, but later on, my lord, they have issued the penalty ticket under Rule 64 of the minor mineral concession rule. In Uma, my lord, 2 points were involved.
Yeah,
in one
just
case.
one.
One is, my lord, whether once, my lord,
Just one. In this regulation, you call it regulation or you call it section?
We call it regulation and
we always say section also, my lord.
we call it section. The main is forest regulation, madam.
No, but nomenclature is section.
Section.
Section 3(4). Yes.
Well, the Uma case, well, 2 points were involved. Well, whether once your lawyer got a copy of the Uma, well, Uma statement, sir.
No, it's okay.
Anyway, my lord,
It's okay. It's available. It's not an issue.
that is 2018-14 SCC 557.
2000.
18-14 SCC 537. So lordship done for it, my lord, I'm just placing two paragraphs here.
No,
Paragraph
I-
119 and 120.
I would not have retained it. I'll just take it. Yes, which para?
119, my lord, your lordship may just see. That section 3, subsection 4, I have placed, you know, that. Your lordship got it? My lord?
How does it start?
The word from is used to denote.
This one. Para 119.
19. This 17 is also important. 117.
No, I'm referring to Supreme Court, the
117, my lord, first your lordship may just see 117. This is a question, my lord, to answer.
in your SCC, you have the SCC version.
My lord, CC, but my lord, in fact, my lord, not true copy, my lord.
Oh, acha.
That is my lord. Yes, CC.
Because in one paragraph, it is as per the National Forest Policy.
No, interpretation of section 2(4) of the 1927 Act. From there, my lord, it starts. Para 117, my lord, my case. Page 589, my lord. 589. Page 589.
Just a minute.
Oh.
Yes, 117.
Yes.
Yes.
The meaning of the words brought from as used in section 2, clause 4, subclause B has become very significant. Well, same thing, well, like our case 3(4). Since it is a case of large number of petitioners that goods which are they are transporting did not originate from any forest area rather than they have taken from non-forest area, and there is no liability to pay the transit fee. Whether the forest produce is defined in section 2(4)(b) should be forest produce which originated from forest or even the forest produce which is merely passing through forest area is still attract the liability of the transit fee is a question to be answered. This is one of the question, my lord, here. Now your lordship may come to paragraph 119. The word from is used to denote a point of time or place where both the words found in and brought from have been used before the word forest. Both the words is found in and brought from have clear nexus with the forest. The true meaning of the words brought from has to be appreciated when read in the context of word found in. The words brought from is an expression which conveys the idea of the items having their origin in the forest and they have been taken out from the forest. The word from refers to the place where from goods have been moved out, that is from the place of their original location. The forest is the birthplace and the origin of the items mentioned in so and so. Subclause B of section 2.4. The word found in mean the item that has originated from forest is found in the forest where brought from means the items have been originated in the forest have been moved out from the forest. The 1978 rules of section 41(27) Act also reflect the rulemaking authority have understood the meaning of the words brought from in the above sense. My lord, you see. And that lastly also in 215, my lord, that your lordship considered earlier, there also the same thing is there, 215(3), my lord, because there, my lord, the some because 2 points are involved, whether once a material is cast, it remains the first position or not. That earlier judgments are Supreme Court there, my lord, that remains at position. Second, my lord, case whether these items are good. My lord, here is the case, these items were brought from forest. Not Supreme Court says passing through forest will not do. Well, change it, it may pass through forest, but origin must be from forest. And that is why 215(3), my lord. Again, my lord, the penalty by conclusion, 215(3) at page 627. The words brought from as occurring in 2.4b of the SIN mean brought from forest where forest produce has been originally the word brought from forest cannot be read as brought through forest. Brought through forest. We however clarify the item data is forest produce. Its origin may be in the forest within the meaning of UP in the state of UP or in the forest outside the state. Well, this is what, my lord, I submit. This judgment is meant for 2 points, my lord. That once the material is cast also, that remains the same, my lord. The earlier judgments are there, that is referred to there. Secondly, my lord, the items, my lord, which are brought from forest, origin is from forest. They are. So, my lord, this judgment is on some different points, my lord. That is why, my lord, I am placing it. So far this case is concerned, my lord, my humble submission is this, my lord. Supreme Court judgment, this Gujarat case is covered, my lord. Actually, this materials are, my lord, we have purchased legally, and thereafter, my lord, trusted then for legally. So they have, my lord, detained the vehicles, seized the vehicles, and then, my lord, this penalty ticket has been issued. So my humble submission, my lord, this is absolutely illegal. There is another case, my lord, here, that is in respect of limestone. Actually, in the similar manner. Just your lordship may take up that also, my lord.
No, I'll take them item wise.
Okay.
The first
All right.
item is item, this, what is the item here?
4.
No.
This is
Coal.
item 4. And
Item
that
number
is
4, where
No, item 4 is item, what is the product?
item 4 is
Stone.
the stone, my lord.
Stone.
stone is common in all the cases.
Stone is common in all the cases.
In item number 5, my lord, our stone quarry regulations is
I'm
under
not
challenge.
5, my lord, 6, my lord.
It is 6 negative.
My lord, item 6 is regarding, my lord, that is also minor mineral, that is limestone.
Item 6 is limestone.
Limestone, and that is
So
the
limestone
old
I'll
case,
take
my
up
lord.
next.
That's the old case.
Let me finish the stone part. Limestone I'll take up later
Well,
because then there will be a different argument
Yes.
altogether.
Yes. And 5 and 8, my lord, 5 and 7 will be similar, my lord, that is whether the license is required for the crushing, my lord, units.
So
Well,
crushing I'll take next.
Yes.
So I am now concentrating on item number 4.
4. And that amendments, my lord, I have just given your lordship me just, my lord, why not the amendments
yes.
are done. All the amendments are there. Just Supreme Court, my lord, why they have done it, my lord, because they are giving some importance to the mines, my lord, that is why.
Okay. Yes.
I'll kindly take up the writ petition further. Why they are insisting, my lord, in this writ petition is apparent, my lord. My lord, may kindly come to page 51.
51.
51. It's the transit salan, my lord. Transit number is there. Date and time of dispatch, my lord will see. Dispatch 23 to 2022. And it was valid till 23 to 2022, 13 hours. My lord will take note of the vehicle number in the second table, my lord, second column, AS23CC0218. Then my lord will turn to the next transit salan, my lord.
You are saying this is valid for 13 hours only.
Yes. Because issued by the DF, Forest Range Officer Sipsagar, my lord, for transporting to Borhat. So sorry, for transporting to Namrup.
Namrup. Hmm.
At the top of the document, my lord, will see name of the range is Borhat. Mahal name Siloni Nagagaon Borhat. Then my lord will kindly turn to next page, my lord. Date and time of dispatch 14 to 2022.
Yes.
Valid up to 14 to 2022. 8:30. 8:32. My lord has seen the dates. Next again, my lord, same 4/5/2022, 5/5/2022.
Hmm.
Next page, my lord, 9/5/2022, 9/5/2022. Page 55, 11/5, 11/5.
Yes.
Now, my lord, will kindly turn to page 59, my lord.
59.
59. It is their own case that were having transit pass, my lord. Now they cannot also.
No. That's not the case. You see, every week I get SCC, loose volume. But I decide to read it when there is a vacation. So will it mean that the January part 1 which I have got in January can't be read in the last vacation which went?
That can be read, my lord. But here, my lord, there is a validity time.
No. You see, that's why I put it that I posed that query to you, and that statement which I made was not just for fun. You see, from the mine area to the to that Namrup, it goes with a transit pass. It is not your case that you have stopped that beyond the transit time. From Namrup, there is an invoice created, and it
Yes.
is sent to Tinsukia.
Exactly.
So for that, you don't require a transit pass.
This is, if we treat this as an invoice,
You see, that is why I made that statement. I told you that you don't want to regulate this because you want to catch the truck drivers.
my lord, these transit passes are issued by the forest officer itself, my lord,
I
for a
understand.
specific time.
But you see, from mine area to that.
Yes, my lord.
So thereafter, it may, you see, the place from where I come from is a marketplace, correct? It's normal in course of a trading. In Hindi, the term is used in Hindi. I don't know the English equivalent. We call it truck paltai, correct? So goods, let us say 2 bags of rice comes in. Back to back, it is taken out from truck A, loaded to truck B, and sent to Tinsukia. Back to back, it's truck paltai, nothing else. So therefore, it may so happen that the 2 bags of sugar which is traveling is after the truck transshipment is made, number one. Or number two, on the same truck, I may give him additional money and say that, well, instead of loading it in Guwahati, do it at Tinsukia. In railway also same thing. The railway wagons are destined for Guwahati. If the commercial manager accepts the proposal, they may extend from Guwahati to Tinsukia. And the same rake goes from one place to another. They charge the money for that. So that can be done. Therefore, there's that question that statement which I was making was, number one, the validity of a transit pass is one thing. Necessity to carry a transit pass along with all consignment.
Assuming, my lord, they don't need to carry transit pass. They're only the existence of a transit pass is sufficient. The driver may not carry it, my lord.
No, not even that. You see, let us say this pen is a controlled item. Correct?
Right.
10 pens were imported from interstate is also import. So let us say we get this 10 pens of this quality from West Bengal, it comes to Guwahati. Now, so far as the first transaction is concerned, 10 pens coming here, that is accounted for. Now from the wholesaler, I get 1 pen for myself. He issues me a bill for 1 pen. So I am carrying my bill.
Yes.
Is it required that I should have the invoice of the seller also?
It is that pleaded case, my lord, that they procured these stone boulders from that stone crusher.
From Mahaldar.
Mahaldar against payment of royalty. Sorry, against which, my lord, these permits were issued by the forest bid officer, my lord. It is their own case, my lord, that they were doing it legally on the strength of these permits, my lord.
No, on the permits of invoice. He said that when you asked me, we got those invoices, the transit passes, and showed it to you. That it was a valid transaction.
Exactly, my lord. Let us see, my lord, on that particular day, what transit pass they were holding, my lord. That is where I am.
No, it is not for it. Is, you see, that's the whole question. If you're putting a wrong question, you get a wrong answer. Where is a requirement of a person? That's why I gave the example of a pen. 10 pens were imported. It is the wholesaler who is importing the pen. I have purchased 1 pen for my use. I get a bill for this pen only. Is it a requirement of law that I should carry the what you call the back copy of the back memos also?
Not required.
Not required.
Here, my lord, he is the buyer, primary buyer, my lord.
No.
He's the first buyer. Mahaldar has, my lord.
Mahaldar has bought in.
Mahaldar
Who is the first buyer? We don't know.
Mahaldar is the, my lord, mineral concession holder.
No,
my lord.
let us take for a time being. Let us assume that Mr. Saivara, the client for whom Mr. Saivara is arguing, is the worst man on the earth. Correct. We go by that presumption. Now the question is that whether he is a first buyer or seller, we are not onto that. He is carrying sand or this aggregate on the basis of an invoice.
Yes.
Now, how do you tackle with that situation?
But he's also required to have a transit pass, which he has already enclosed, my lord. Page 51 to 55. That is his pleaded case, my lord.
Shows that. Shows that.
Invoice is okay, my lord. Page 51, my lord has seen annexer 6.
Just a moment. Just 6.
Paragraph 8 is the corresponding paragraph, my lord.
Yes.
That the petitioner states that since the inception of the petitioner stone crushing unit, the petitioner had only involved in crushing of stone into various sizes and thereafter forwarding distribution of parties in and around the district of Tinsukia and Dibrugarh for the purpose of stone crushing transportation of crushed stones. No other permission is required under Assam Forest Regulation and also under Assam Minor Mineral Concession Rules. In the normal course of business, petitioner purchased stones from various government appointed lessee permit holders and brought the uncrushed stone to the stone crushing mill of the petitioner. In this regard, petitioner has purchased and used royalty paid stone, which is apparent from the issuance of e-transit pass by the department. The royalty has been paid to us, to the state, by the concession holder, my lord. He has taken that area for mining against the license issued by us, and for that we are getting royalty. And after that, my lord, he is selling it, my lord. He's selling it to someone, and that sale, my lord, is endorsed by way of a e-transit pass. Yes, my lord, because we have to see, my lord, transportation also, my lord, we have to see whether it
Which
is
according to
illegal.
you is e-transit pass.
My lord,
Page 51 is the e-transit pass.
my lord,
It is valid from the Mahal area to Namrup.
exactly, to his
Now,
Kasar unit.
look at page 57, that is his invoice. This invoice is from Namrup to Tinsukia.
It is for, my lord, some other parties who has procured from him, my lord. It is not for him, my lord.
This vehicle
Name,
was
my lord,
intercepted
will
where?
Vinayak dues.
So it was intercepted where?
It was intercepted in, my lord.
That will be in your charge.
Dibrugarh,
Dibrugarh.
Jaipur range.
So therefore, it is.
We only want, my lord, that if EUA bill or this, my lord, tax invoice for that particular day, they are annexing documents of some other days, and for the day in question, my lord, they have produced nothing. Let them produce it, my lord, will release. That is why, my lord, I was taking your lordship to the dates. Dates are relevant. Whatever dates annexers you have annexed, my lord, doesn't pertain to the date in question.
No. You see, that is why Mr. Sahiwala is referring to this Jais Bhai. He says that after it has been procured, then there can't be a fetters in interstate trade and commerce. Therefore, you can't insist on the transit pass now.
Whether it is legal or illegal, that has to be seen, my lord. Supreme Court is clear, my lord, that there cannot be control in legal trade, my lord. We have just to monitor, my lord, whether it is legally procured or illegally procured, because there are illegal mining also going on. If they buy it from illegal miners, state is losing revenue. That is why this transit thing, my lord. Because section 23 also says
You can merely go and check with these people whether they have sold it to the petitioner or not. But to
that is the transit pass, my lord, issued by the forest department against the concerned.
where is the requirement that from a trader, e-pass, what you call transit pass is required? Where is that? Show us that.
I will try to find out. Just
Because this requirement of RK Stone Mills to issue a transit pass to the petitioner, that is the only thing you have to show. Page 57.
That transit pass is issued by forest department. RK Stone Crusher Unit petitioner will go to the forest department. They will say that we are purchasing this amount from the lessee, my lord, and against that we need a transit pass. Transit pass is issued by the forest department. We don't charge anything, my lord. It's not charging something, my lord.
Where is that? Show me that scheme.
Section 40 of the Assam regulations, my lord, 1891, empowers the state.
47.
Section 40 of Assam Forest Regulations 1891. Conduct has my lord got it, ma'am. Section 40 of Chapter 6,
Yes.
Assam Forest Regulations 1891.
Yes.
Power to make rules to regulate transit of forest produce. The control of all rivers and their banks as regards the floating of timber, as well as control of all forest produce in transit by land or water is vested in the state government, and that state government may make rules to regulate the transit of any produce. Such rules may, among other matters, prescribe the route by which alone forest produce may be imported into, exported from, and moved within the territories to which this regulation extends. Prohibit the import, export, collection, or moving of forest produce without a pass from an officer authorized to issue the same, or otherwise then in accordance with the conditions of such passes. Provide for issue, production, and return of such passes. Fix and authorize any forest officer subject to the control of the state government to fix the fees payable for such passes. In the case of timber formed into soil, it is not relevant, my lord. F. Provide for the stopping, reporting, examination, and marking of forest produce in transit, in respect of which there is reason to believe that any money is payable to the government and to which it is desirable for the purpose of this regulation, and to fix a mark. establish revenue station to which forest produce is to be taken by the person is son. So en route, my lord, there are so many mechanisms to check, my lord, whether the forest produce in transit is legally procured or illegally procured. We are only concerned with that, my lord. If he has procured it from legal, so as he has already annexed page 51 to 55, my lord, those are legally procured because we have endorsed that you can now take it to your stone crusher unit by a forest department. And for that particular day, my lord, we want issue them a notice, ask them to serve us, provide us with the document for that particular day.
No, you
transit.
see, that's what I'm asking you that question. You see, I have got an SCC in January. I'm reading it now. If you say me that, please show me, you are holding this book and reading it. Please show me an invoice of today that you have purchased this book today. This book I have never purchased today.
True, my lord.
I purchased this in January.
True, my lord.
I'm reading it now.
It's a book, my lord. We are about a mineral, my lord, with
it's okay.
in transit. So for that particular day, my lord, that is why there is a validity time also, my lord, not only date. Within that period, he has to carry out.
You see, there can, under no law, there can be a presumption that the stone crusher which receives the aggregate or the stones on a particular day will have to crush it in the same day and sell it on the same day.
Not crushing, transportation to his
No,
crusher
it's
unit.
okay. No.
This is a e-way bill, my lord, for transporting to his crusher unit. He may crush it after 1 year, my lord. We are not bothered with that. We are concerned with the transportation, my lord.
No, actually, I'm getting you because of the, come to page 57 first.
Yes, my lord.
57 is 6 mm stone chips,
My lord.
12 mm stone chips. So
My
these are the two items.
My lord.
So that has been crushed.
Already crushed.
Correct. So now the original transit or original mineral is not before us.
Yes.
Correct. Now this is the one. Now you have to show that there is a requirement that the processed mineral
My lord.
must be carried by virtue of a valid transit permit. Because you ask somebody to show that whether you have got the bill, he has shown that, okay, I have got 10 bills, 10 pence I have procured. So that is okay. He gives you that.
So my lord is basically on post crushing.
You see, my statement, the first statement I made before Mr. Saiwala started. What was that statement? That you don't
Now I got it.
go to the source. You're catching the truck. And I also said that you don't have that regulation or permit saying
Once
that
it is crushed.
once it is crushed, that permit.
I got it.
So I'm putting those questions in a sequence.
I got it. Once it is crushed, whether these regulations will be applicable or not.
Not even applicability. I'm on the validity of your transit pass. You say that you need a transit pass. Very well. Have it. But show me the provision that after crushing also they need a transit pass to carry it.
And now I understand.
And
I
that is
was,
why
of the view that from mineral area to the crusher unit, my lord has seen that after it is crushed.
now, yes.
Now it is, my lord will proceed at 2, my lord. I will take instruction from our client. Or tomorrow morning, my lord. It will come from Dibrugarh.
No, not tomorrow. Tomorrow I have already 53 matters listed except for in addition to
Next Tuesday, my lord.
next Tuesday.
I will get it because DFO may not be able also. I will have to
No, it's okay.
check with 3
Because that is why
And now I
I'm
got
asking that the pattern of
Yes.
questioning is on that
I got
manner.
Had it not been crushed, it was en route to the crusher unit. That would have a different situation. My case was basically based on that. I got it.
Tuesday then.
My lord,
Let the additional G have
my lord, the
instructions.
other matter, my lord, the
I'll take one by one because
no, only one that limestone matter may be taken up because that's a different.
okay.
Because limestone is already, my lord, what they does not come. in the
Take up all the matters together, my lord.
No,
Finish
no,
up
my lord, limestone maybe, my lord, because I shall place, my lord, the PL.
We'll take it up on Friday.
Hello?
Sorry, on
Tuesday.
Tuesday we'll take it up. Tuesday we'll take it up. Because if I can't conclude, it's very difficult to retain it.
My lord. Correct. Only thing because, my lord, the limestone is, because that's the old case, limestone was not in the forest, my lord, department. It is mineral department.
There is
Interestingly,
an order passed by me. You
my
please go
lord,
through it.
appreciate
No,
one thing.
that
My lord
order has
declined
been-
to pass an interim order.
But that
because-
order has been staged by
No,
the division
no.
bench.
That is where I am.
Just a moment. in terms of this,
Who might have?
no, no, no. In respect of this limestone,
Yes,
there's also one order passed by me.
that I have, my lord. And that has been.
That has been challenged in
written
reappeal,
and
my lord.
stated.
Reappeal, my lord, there is an interim order because my lord declined to pass an interim order and remanded back to the single bench. my lord.
Yes, it is ordered. My lord, your lordship may just.
While
my lord,
issuing notice, my lord, did
Division
not pass
bench.
any interim order, my lord. That limestone matter. Against that, my lord, the writ appeal has been preferred. My lord, in the writ appeal, my lord, honorable division bench has passed an interim order. They granted an interim order and sent back for decision on merit by the single bench. my lord.
Okay.
My lord, just 9 minutes.
It will be like-
Because the earlier, my lord, the PL judgment is also there, my lord. This is the PL judgment. Not PLs.
Item number 7.
Okay, I get it.
That repetition may also be clubbed, my lord.
That
That repetition.
No, I'm not clubbing it right now
My lord. Tuesday.
because I'm taking up assigned matters only.
My lord.
I will
my
not.
lord, that so far limestone is concerned, my lord, the PL judgment also have given. My lord, because that is beyond the forest department, they themselves admitted.
Okay, Tuesday we'll take it up.
Well-
That will be taken up on Tuesday.
Remains self-department.
On Tuesday, irrespective of this matter, that also will be taken up. In item 4, you write, Mr. G. N. Savala, Senior Counsel, assisted by Mr. P. Decker, Counsel for the petitioner. So his argument is concluded, reserving right to reply. The submissions of Mr. P. N. Goswami, Learned Additional Advocate General, remains inconclusive. List as a partner matter on Tuesday,
My lord.
25/7/2023. And this item
Rest will follow, my.
for item 5 to
7.
5 to 7. Here you write list on 27/7/2020.
27. 25, my lord.
25. 25. This will be 5, 6, and 7.
5, 6.
Okay. I'll try to take it up.
That copy also has given, the PL with them.
Yes. Second pile easy. I'll take a break and come back.
Much.
Kalau rasa itu, bila itu sukses berada.
Oh, money क्यों different color itu nih justru register sih इसको only कितने asal है itu kita correction tuh kita ya itu item फोर को पार्ट था और बाकी मिलता है डेट उसी का ये देखिए इससे Aí eu gosto de é um bom número. আচ্ছা নবনীতা আহিছে নাই আহিবনে নাই মই কৰিম বাৰু দেই দেই পাইছো নবনীতা নেকি বৰ্ষাটো আপোনাৰ এটা হেৰি চলিছে হয় হয় কৈছে আহিব লাগিব ন মই কৈছো কৈছে গৈ আছো তাই টাইমটো ফিক্স হৈ থকা নাছিল নেকি বেয়া নহয় বাৰু ব্যৱহাৰটো ভালেই লাগে এনেকুৱা হ'ব 30 তাৰিখ দাদাৰ এই নাই দাদাই ওজন আৰু দুখমান কামটো বেছি এনেকুৱা নহয় যে Item 8.
Page 18 is the Indian order, madam. And in 20 this Assamese version is 20 is the original order. This order is passed by the settlement officer. Cycle officer, madam. From the
Page
but my lord, 18 is
18.
18. This is translated copy, my lord. 20 is the original order. Subject matter is she got half plan.
Mr. Sharma, you are appearing for this.
My lord.
Private
responding for-
respondent?
Yes,
Will have to interfere with this order.
my lord, what happened, my lord, in the schedule, my lord. The, that number is my lord 7, patta number is my lord, KP patta number 23, my lord. My land, my lord, which my lord I am possessing is the government land, my lord. That's why, my lord, I have filed affidavit, my lord. So the land claimed by the my lord petitioner is the distinct and different land which is in my possession. My lord.
No, you see,
The allegations is against me, my
he's
lord.
challenging page 18.
My lord. Page 18 is the order passed by the my lord circle officer regarding my lord restraining the my lord for any construction, my lord, and status quo as regards the plot of land, my lord. That's my lord order, my lord, is also since the order passed by the circle officer, it's a my lord appealable order, appeal to the deputy commissioner, my lord, under section regulation 147 of Assam Land and Revolution. But my lord, in the present petition, my lord, the petitions, my lord, they raise the point of section 7 of the Police Act, my lord.
Also,
Section 7 of the Assam Police Act, my lord.
Police Act.
Yes, my lord. They, my lord, their contention in the writ petition is that the my lord, the deputy commissioner has, the circle officer has no jurisdiction to pass the my lord, the present order. This is as per provision of provision of section 7, my lord. Their contention is barred.
No. You see, is it legally permissible? Circle officer to say that the possession could not be decided, therefore status quo. He's not a civil court.
That's true, my lord. But
Then-
my submission is that, my lord, the land which is in my possession, my lord, I have filed affidavit and I have also.
No, this is not a proceeding under 144.
Yes,
It's not a proceeding under 133.
that's my lord.
Not a proceeding under 145.
Yes,
Then how does he get the power? The circle officer or assistant settlement officer must derive power from somewhere.
status quo, my lord, in the sense of, my lord, not to make any disturbance of public tranquility, my lord. That's why maybe passed, my lord. Otherwise, my lord,
You see, number one, when he puts his signature as circle officer, he has got nothing to do with the law and order. He's signing as assistant settlement officer. And under the Land Regulation Act, it's something new to me. Under Land Revenue Regulation, circle officer has to do law and order duty. When is a person called a circle officer? What jurisdiction he is doing, he is acting on when he's signing as a circle officer or an assistant settlement officer.
lordship, maybe please to, my lord, record my submission that this, I will satisfy, my lord, I have also annexed the document, my lord. The plot which is in my possession is the different group. That submission may be recorded, my lord.
No, in fact, you see, there must be some basis. A police officer feels satisfied that X who's traveling from the road, walking on the road, may be a future threat, and therefore shoot him down. Only satisfaction is to be recorded that I see from the face of this man that tomorrow he may be a potential terrorist, and therefore I shoot him down. He records satisfaction. I record a satisfaction and then say, okay, X appears to be a terrorist, shoot him down. Because when I'm acting as a judge, I am also acting as a magistrate. I have the power under CRPC. What is that? 44, 46, what is that? 44.
Regulation, my lord.
CRPC,
Uh,
if any crime is takes place in cognizance of a jurisdictional magistrate, no, it's okay. Huh. Whatever. And don't worry, under the CRPC and in the IPC, magistrate is also a judge. 44. Arrest by a magistrate.
Magistrate. When any offense is committed in the presence of a magistrate, whether executive or judicial within his local jurisdiction, he may himself arrest or order any person to arrest the offender and may thereupon subject to the provision therein contained as to bail committed the offender to custody. Any magistrate or executive or judicial may at any time arrest, direct arrest.
Correct. So what I do is that, assuming that I am a magistrate, I think Mr. Bokalial is a potential threat. I'm sorry for it. Huh? He is a potential threat. I say that I issue a warrant for inspection of his car. And I know in the car a screwdriver will be available. Correct. Screwdriver is a potential threat in an aircraft. When you fly, you can't carry a screwdriver. It is a potential threat. And since it is a potential threat under the Air Carriers Act, what I do is that I order that Mr. Bokalial be arrested. But I am recording my satisfaction everywhere. I am a magistrate, I am recording my satisfaction. That yes, my threat perception is because in the aircraft I am not allowed to carry even a small scissor, knife in the what you call nail cutter. You are not allowed to carry it. So it is a potential threat, and therefore I record my satisfaction that Mr. Bokalial be Mr. Bokalial, sorry, huh? It's only an example. It has to go.
My lord, Lordship may kindly, for my satisfaction, my lord, Lordship may kindly, there is the, my lord, page 48 of my affidavit.
Page 48.
My lord,
Yes, please.
the part of the, my lord, Sadar Jama copy, my lord. Lordship got in, my lord. Pursuant to the order dated 29/5/76 by the additional district deputy commissioner in Chilling case number so and so, and pursuant to the order number so and so, SDC, a plot of land measuring 8 bighas, 1 kotha, 15 lesa covered by Doug number 23 of Patta number has been created a new Doug being Doug number 181 and deleted from the settlement of the year 1983 and declared as government land. That, my lord, the 181 plot of land which, my lord, I have purchased from my vendor, my lord, that lordship will find page 49. This is, my lord, the after sealing, my lord, that plot of land has been declared as, my lord, the tag number 181 and declared as government land. Now lordship will find page 49.
Page 49.
My lord.
Yes.
My lord, I have purchased the possessory right, my lord, of 2 kothas of land, my lord. That lordship will find schedule of the land, my lord. In the bottom, my lord, a plot of land measuring 2 kotha covered by Doug number 181. This is the government land, my lord. And my lord, I am that land, my lord, I am possessing, but subsequently, my lord, what happened on 6/9/22, my lord, the one lot mandal of that revenue circle, my lord, has snatched away my key, my lord. And while, my lord, I am cleaning my plot of land, and that plot of land, my lord, I have purchased, my lord, in the year 2010, my lord. This is not a, my lord, what they have alleged in the writ petition, my lord. It is not a recent, my lord, that I have cleaned that plot of land, my lord. Since 2010, my lord, I am possessing that government land, my lord. And, my lord, I have lost also FIR that lordship will find page 57, my lord. And subsequently, my lord, what I am, my lord, submitting that the plot of land which, my lord, I am possessing that the schedule of the plot of land boundary, lordship will find at page 50. Lordship may kindly 50, my lord.
Yes.
Lordship will find in the north PWD road, my lord, in the south Mohansetri, east Novosetia, west Prest. Lordship may kindly note that in the north PWD, my lord. In the, my lord, I have collected one, my lord, power of attorney executed by the, my lord, petitioner, my lord, that lordship will find at page 68, my lord. Lordship may kindly peruse the boundary, my lord. This is the, my lord, power of attorney executed by the petitioner number 2. This is, my lord, 2007. That lordship will find the schedule, my lord. In the, my lord, south, lordship got it, page 69. This is their power of attorney. Page 69, in the south, lordship will find PWD road. In my plot of land, it is north, my lord, and in their plot of land, it is south. So both the land, my lord, in between, my lord, there is a, my lord, PWD road. It is, my lord, in the opposite direction, my lord. So my submissions is that my plot of land, which I am possessing since 2010, my lord, is not the plot of land which, my lord, the petitioners is claiming, my lord. And subsequently also another, my lord, the power of attorney executed by my lord petitioner number 1, my lord, that lordship will
Your
find page-
argument would have been good for any other purpose, but to defend this order,
No, my lord, that order is also, my lord, I have challenged before the, my lord, deputy commissioner, my lord. That's why, my lord, in so far the order is concerned, my lord, I have also challenged that order. But
so
the
therefore your
grounds,
rights and
that observation may be recorded that this plot of land is, my lord.
I'm not saying anything. I'm not deciding anything, but I'm saying that if you have any bona fide claim or objection, you can raise that in an appropriate forum.
I have
I'm not
raised also,
deciding
my
a
lord.
right alien interest, or I'm not putting any words with regard to the entitlement of any party, neither petitioner nor respondent. Heard Mr. DCC Pukal Leonard. Mr. DCC Pukal Leonard, counsel for the petitioners. Full stop. Also heard Ms. G. Hazarika Leonard, Leonard, standing counsel for the Revenue Department, appearing for respondent number 1. Mr. G. Bokalia Leonard, government advocate, appearing for respondent number 2 and 3. And Mr. R. Sharma Leonard, counsel, appearing for respondent number 4. Next paragraph. The legality of the order dated 16/9/2022, passed by the circle officer and additional
Assistant
assistant settlement officer, Chandrapur Revenue Circle, is under challenge in this writ petition filed under Article 226 of the Constitution of India. So the petitioners claim to be owners of land measuring 14 bigha, situated at Khonkar, Khangkar, Gaon, covered by Dag number
7.
Number 7.
no, covered by Covered with part of dark number 7,
My lord,
correct?
yes,
Covered with dark number 7 of KP Pata number 23 of village
Concord,
Khongkar, KHANGKAR, Gaon, under Chandrapur Revenue Circle,
Concord.
which is a part of such land was sought to be grabbed by the. It is projected that the respondent before was seeking to grab a part of the said land. Full stop. The son of the petitioner number 1 approached the circle officer, Chandrapur Revenue Circle, within bracket respond number 3, for taking necessary action. Full stop. On the said application, comma, the circle officer come assistant settlement officer within bracket respond number 3 pass the impugn order directing status quo to be maintained in respect of the said land. By the parties, i.e. the petitioners as well as respond number 4. Full stop. Next paragraph, per contract, comma. The learned counsel for respondent number 4 has submitted that the land was originally a patta land. However, by virtue of order passed, order dated 29/5/1976, passed by the Additional Deputy Commissioner in sealing case number 741/76/700/76. These are 2 cases or 1 case? Is there a typing error?
No, my lord. Lord, there may be 2 cases, my lord, because 2 numbers are there.
Huh?
2 numbers are there. That's
2
why.
cases are there.
46,
2 cases are there.
Page
Then it's a
46.
typing mistake. Okay. Sealing case number 741/76 and 700/76.
2 cases.
Comma, a plot of land measuring 8 bigha, 1 kata, 15 lecha, covered by dark number 23, patta number 7, was converted into a new dag bearing number 181, which was deleted from the settlement made in respect of the year 1983 and declared a government land. Stop. The counsel for respondent number 4 projects that he was in occupation of the said land. And accordingly, the counsel for respondent number 4 disputes the claim of the petitioner of being the owner and possession of the land in question. Next paragraph. Having regard to the nature of claim and counterclaim in respect of the said land, as posited by the petitioner and the respondent number 4, comma, the court is of the considered opinion that the High Court in excess of jurisdiction on Article 226 of the Constitution of India would not be the appropriate forum to decide disputed questions of fact, and therefore the issue relating to the right, title, interest, and ownership of the owner, right, title, interest, and possession of the land in question is left to be decided by a competent court having jurisdiction. Next paragraph. The challenge in this writ petition is the order dated 16/9/2022, which is extracted below. You type it from page 18. In the top, you write English translation. And this number is wrongly written. Blue pencil, number is wrongly written. You see it from SMS at page 20. Eighteen and 19, huh? This order. You see from page 20, you'll understand, huh? Form is different, typing it is different. Next one. The on a perusal of the aforesaid order, I mean, it cannot be said that which particular provision of law was invoked for passing the said order. Full stop. None of the sides could show that a circle officer come assistant settlement officer can be deemed to be a magistrate within the meaning of who is that, CRPC? Is a magistrate within the meaning of Section 3 of the Criminal Procedure Code. Therefore, comma, a circle officer, comma, assistant settlement officer would not have power to power under section 144, no, sorry, 133, 134, 144 and 145 CRPC to pass orders for maintenance of for removal of nuisance or to pass orders in urgent case of nuisance or apprehended danger. or to take cognizance of any event which is likely to cause breach of peace. Postal. Moreover, the as indicated, as already indicated above, the hearing before referred order dated 69/2022 does not disclose the source of power for directing the parties to maintain status quo. So accordingly, the court is inclined to hold that the impugn order under memo number CPC within bracket MISC bracket closed 9/2022 part of the 1009 dated 16/9/2022 is not sustainable on facts and in law. And therefore the court has no hesitation to set aside and quash the said order passed by the circle officer come assistant settlement officer, Chandrapur Revenue Circle. Next paragraph. Nothing contained in this order is to be construed as if the court has rendered any opinion in respect of the right, title, interest, or possession in respect of any of the parties, i.e. the petitioners or the respondent of four. And therefore, in case the parties are advised to approach the appropriate court/forum, they said court/forum shall decide the matter independently without being influenced by anything contained in this order. Represents party allowed to the extent as indicated, stands allowed to the extent as indicated above. Next part, the parties are left to bear their own cost.
But the magistrate power is seized by section 7 of the Police Act. Assam Police Act. Because when the police commissioner is there, the magistrate cannot take cognizance of the administrative power.
What have I said in my order?
Yes, yes.
What did I say in my order?
Hello. Hello.
Then
Hello.
Item 9.
yes, Mr. Das.
May please, Lord. Some stage, my lord, you lordship heard the matter, my lord. And after there is a matter, my lord, you lordship pass an order on 29/5/2023, my lord. For the I am drawing your lordship attention, my lord, to the order passed by your lordship, my lord. And the order occasion, my lord.
Yes,
Ultimately, they have not filed their affidavit of official, my lord, whether your lordship will finally dispose of the matter. Those in affidavit, my lord. You want me to me, my.
We have received an instruction. The fictional society is in possession of the same matter. And in respect of my lord, regular settlement matter, although my lord that order letter has not been annexed, my lord. Lordship may pays the pay is 43 of the petition, my lord. Last paragraph, my lord.
no, you see, by the time you get instructions, the instructions become outdated.
Right.
You see, what has happened here, this extension of settlement of a year was from 30/6/2022
Yes.
till 29/6/2023. So that has expired in the meantime, because your instructions are of 7/6. In the meantime, the term is gone. Now, the only question is that coercive action for recovery.
My lord, since you have filed a representation, my lord, that can be taken call by the my lord authority.
No, his challenge is that the government is wanting to take steps for recovery of the money
Yes.
from him. And he says that the part of fishery was never handed over.
That is also.
So your
reflected in the
instructions
order,
are
my lord.
inadequate in that respect.
The instruction says that my lord from 36 he is in possession.
No, this instruction is of 7/6.
7/6.
So after 30, after 29, what is happening, you don't know.
Yes.
Yes. And this is something which is not required.
Yes.
In fact, the only question here is that Mr. Das is, the case of Mr. Das is that you gave him the fishery, did not hand over the entire possession, and therefore he claims emission. And in the meantime, he apprehends that the government, without deciding that, would take coercive steps. That is the only case. So we extend the interim order, you take instructions. Correct.
I give it to you, Lord.
If your
Actually,
lordship,
my
my lord,
lord,
use the phrase 43, my lord.
Page 43, yes.
Page 43 last paragraph, my lord. Of their representation, my lord. Process for regular settlement is also, my lord, there, my lord.
No, I don't think Mr. Das is agreed by the retention process.
Please, my lord.
He is not on that totally. He said that you wanted to give him the fishery and he refused to take fishery.
Right.
Correct. His stand is that you are not giving the entire fishery, therefore he is not ready
No,
to
actually,
take up the
my
fishery.
pair for extension that was for about 3 years, my lord. As against which only the government has granted only 1 year, my lord.
1 year, he's not taking it.
That was not accepted by the Pediatrician Society, my lord. My lord,
But
who is the
if
question
I-
of making payment of
Coercive action, that can be,
even
my
for
lord,
this
step,
period?
my lord. But my lord, if regular
Mr.
settlement
Das,
is my lord,
instead of this, can we relegate you to the, what do you call, to the secretary, fishery,
My lord.
to take a decision
Yes,
on your
ma'am.
petition?
My lord, that is also my prayer also, my lord.
So
That
we dispose it off
subject-
instead of keeping it pending.
No,
Yes, my lord.
subsequently, I'm saying I have submitted an application for granting extension, my lord, for a period of 3 years.
So he decided
My
within a
lord,
period of,
let that matter be decided by the.
within an outer period of 1 month.
My lord, let that.
Correct.
Yes, yes. Even my lord, if the meantime, my lord, regular settlement process is initiated, my lord, that can be.
You do whatever you want.
You say interesting, my lord, that's why I am drawing to page 35, my lord, in extra 7, my lord. You see how this, the action of the land, the addition, the deputy commissioner, the provider, my lord, could be, my lord, allowed. Contacted them, the deputy commissioner was directed to submit a report, my lord, on my application for extension. On thrice, my lord, he was remanded, my lord, by the annexer 7, my lord. Just to cover up their lapses, now they have come with this demand notice, my lord.
Mr. N.C. Das, Learned Senior Counsel, assisted by Mr. A. Das, Counsel for the petitioner. And Mr. M. Setial and Government Advocate appearing for all the respondents.
Yes, my lord.
Next, please. In brief, the case of the petitioner is that the petitioner society was granted lease in respect of number 1, Saulkhoa, Chaulkhowa, river fishery for a period of 7 years. Commencing from 25/6/2015 to 24/6/2022 at an annual revenue of rupees 12 lakh per year. In this regard, fishery lease dated 25/6/2015 was executed. Full stop. the petitioner claims that it could not run operate the fishery smoothly, partly because of lockdown during the COVID pandemic period, encroachment of the fishery, and other factors for which, though they suffered financial loss, but paid the lease the lease rent periodically. Full stop. On 10/3/2022, a representation was submitted before
Before the joint secretary, my lord.
before the joint secretary to the government of Assam, fishery department. It is called fishery or fisheries department, IES,
Fishery department.
fishery,
Fishery.
fishery department, for extension of lease for a further period of 10 years with an alternative prayer for granting remission of revenue. Full stop. However, the said authority, by order dated 17/12/2021, extended the period of lease for 1 year, i.e. from the period (30/6/2022) to 29/6/2023. Dates are right?
Well,
Dates are right?
but in the order of extension, my lord, period is mentioned only, my lord, 1 year is extended, my lord.
Where is the order?
At page 22, my lord. This should be the period of 1 year will be run from the date of execution of the lease deed, my lord, and also for ending of a possession.
No, you see, this date came from your synopsis. In your synopsis, see page 2, you are writing a date.
3 years.
You have seen in the middle.
My lord.
So I go by the theory of what you, what I read is what you get.
Well, of course, your lordship is correct, my lord, perfectly. But in the they say the extension order, but
This is
the
then don't
period
give
is
the
not
date.
mentioned
Don't give the
only-
date for a extended for video 1 year.
Oh,
Okay, I'm not giving the date then.
Right.
Extended for 1 year. Full stop. The London Senior Counsel for the petitioner projects that he could not operate the fishery for the said extended period of time because the fishery was not formally handed over to the petitioner. And therefore, it could not be
They are liable to fall.
the position of the fishery could not be taken over. Full stop. However, by the impugn notice dated 4/3/2023, the Secretary of the Petitioner Society was directed to pay the lease rent of rupees 11,86,500 for the extended period Where is this notice?
Page 36, my lord, and these are 8,
36.
36. There is type copy, my lord. And a vernacular copy is at page 38, my lord.
Here is the date.
But that is my.
For a period from 36/2022 TO2
My lord.
29/6/2023. Full stop. Therefore, comma, the petitioner has opposed this court by filing this petition under Article 226 of the Constitution of India, apprehending coercive action against the petitioner society for recovery of a sum of rupees 11,86,500, purportedly towards lease rent of the revenue for the period from 30/6/2022 TO to 29/6/2023. Next paragraph. The learned government advocate has produced a copy of written instructions dated 7/6/2023, received from the additional deputy commissioner within bracket fishery, bracket close Borpeta, wherein it is stated that the fishery is in possession of the petitioner society since 30/6/2022, as per the field verification report. The correctness of this said report is disputed by the learned senior counsel for the petitioner. Next paragraph, be that as it may, comma, the case of the petitioner is that he had submitted a representation where is that representation?
Page.
Page 43.
Is a by for it, that is a by page 43, my lord.
The representation dated 13/5/2023. Addressed to the additional deputy commissioner within bracket fishery, Borpeta, with copy to the joint secretary, fishery department, joint secretary, government of Assam, fishery department, for the course of the considered opinion that this would be a fit and proper case to delegate the petitioner to once again move the competent authority, i.e. the joint secretary to the government of Assam fishery department, with a fresh, with a supplementary representation full stop. The petitioner shall produce a certified copy of this order and submit a supplementary representation to the joint secretary to the government of Assam fishery department within a period of 10 days from today. Full stop. On receipt of the same, the said authority shall give an opportunity of hearing to the petitioner and dispose of the said representation within a period of 1 month from the date of receipt of the certified copy of the order. Next one. Till such time the representation of the petitioner is decided, the respondents, the interim order passed on 29/5/2023 directing that coercive steps for recovery of the lease money would not be initiated against the petitioner. Would stand extended. It stands allowed to be extended as indicated above. The You give a photocopy of this, we'll keep it here.
Yes.
The learned government advocate shall provide a photocopy of the instructions to be retained on record. Continue to.
আমি করি হ্যাঁ হয় আছে মানে এতিয়া আৰু আছে অলপমান ধৰি লওক এতিয়া নলৈকে গৈছেহে আৰু ধৰি লওক 7টা মান আছে আপোনাৰ কাৰণে অলপ প্ৰেচাৰটো বেছি হৈছে ন হয় হয় মই বুজিছো বস্তুটো মানে প্ৰম্পট হোৱা নাই আৰু সেইকাৰণে আপুনি নকওঁতেও মই গৈ অলপ চাউণ্ডটো বঢ়াই দিছো হেল্ল' তেখেতে 12টা বজাতে গ'ল আৰু মানুহটো দেখা দেখি নাই আৰু কেতিয়া আছে আছে আগে থাকাটো ভালো বেলেগ আছিল কিন্তু অকলে আছে আইটেম নম্বৰ কিমান 19 আর 20 no hearing ঠিক আছে daily 5 years আইটেম 4 পার্ট হার্ড হইছে আকো 25 তারিখে বিটিডি কি কলে আপনি
বিটিডি শো করেছে এখানে আমি
কোড শো কৰিছে
প্রসেসর বিটিডি বলি
নাই নাই এই এইটো কল্যাণৰ সুৰানা ছাৰৰ কেছ এইটো আইটেম 4 বিটিডি নাইটো
কি আছে
এসসি ফৰেষ্ট বুলিহে আছে বেলেগ কোডৰ আইটেম
Okay.
হ্যালো ও আচ্ছা 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 ঠিক আছে থ্যাংক
Provision of law. So what I am suggesting is, my lord, because these are all disputed questions of facts and law, my lord. mostly, my lord, if your lordship goes into page 139 of the writ petition by which their certification has been cancelled. So against this, my lord, as per section
This is,
11.
this is, what you call, election to the union.
My lord,
Indian registration of the union has been cancelled on the basis of the complaint filed by us. So against that order, my lord, there is a statutory appeal.
Under which provision?
So section 11 of the Trade Union Act. So there is a my lord, interim order protecting their rights. The lordship may relegate the matter to the appellate authority to do the needful within a period of 1 week or 1 month. Because they are in the know of the matter, and these are all factual matters. Yeah, till then,
Just
interim may
pass me a book.
continue till decision.
Pass me the second book. Yeah, okay, I got it. Shortcuts appear to be better.
Your lordship cannot decide the matter also. Difficult one.
Section?
11.
I thought there would be fireworks and therefore I asked Mr.
Before the
Sharma.
fire begins, I wanted to douse it.
No, Mr. Sharma, I requested him to leave just anticipating fireworks here. Section 11.
11.
But here it says appeal to the High Court.
Where the trade union is situated within the limits of presidency town.
Okay, so this is not Calcutta.
Yeah.
Okay,
And next is where the head office is situated in the area.
Industrial Tribunal
According
to
to
Court.
the
Okay,
jurisdiction of the labor court or industrial tribunal to that. Court.
okay.
So it is from. If you go to that
Dibrugarh, there is a tribunal.
tribunal.
Yes, Mr. Sarvana, what do you say about that position?
Because interim protection which is there, Malad, it is
Yes,
constituted
purpose notice has been issued under section 10C. And action has been taken under 10B. And moreover, certain time has been not granted, well, as per the provision. I can test, well, earlier also we have approved this for the occasions. That is why I have given down a list of debts, my lord. Your losses may just see, my lord, list of debts. We are supplying them to copy, my lord.
What is the difference between 10B and 10C?
Yes. And that point has been raised before the High Court also. They have not changed it. 10C registered.
Your lordship will decide whether Malad, the appeal is maintainable in terms of my paragraph 3. Lordship may decide whether to hear the matter on merits.
Yes.
Now, my lord, 2498, my lord,
My lord,
the union was
the
registered.
conducting counsel for respondent number 5 and 6 is out of station, so kind of
Maybe 1 to 4.
one. আর তিনি হাজার দিচ্ছি। Thank you.
Yeah, adjudicating authority, my lord.
1 to 4. Respondent.
Labor Commission.
That is
Labor
adjudicating
Commissioner.
authority, my lord. Adjudicating authority. Yes, to, my lord, each order is another challenge, my lord.
Who's the counsel?
Jyotimay Roy.
I think there, the insofar as the labor is concerned,
Yeah.
they can't be a contesting authority. The contesting authority would be the president, the petitioners and the respondent union.
Correct.
Will be there, just be there. Yes.
My lord. my lord, the list of dates, my lord, I have given.
Hmm.
2498, my lord. The petitioner was registered in the year 1980, having registration number so and so at that point of time. Name was Technical Workers Union. 11/5/13, my lord, in the year 13, resolution was adopted by general meeting of the union held on 11/5/13 to change the name of the union, and the name of the petitioner was changed from Technical Workers Union to Oil and Gas Employees Union. Annexure 50, my lord, this is not required. Then page 151, my lord. Hey, this fourth one. Labor officer Dibrugarh, by letter dated so and so ascertained the Deputy Labor Commissioner Assam that a general meeting was held on 11/5/13 and the records of the general meeting along with the names of the membership was verified and found genuine. My lord, we have applied for change of the name and the labor officer inquired it and found to be genuine. Then, my lord, response number 2, by letter dated 8/11/13 intimated the amendments as sought for in the trade news notification has been registered on 7/11/13. So our name has been changed, my lord, 7/11/13. Now, next, my lord, response number 2 issued a so cause dated 22/3/17, directed the petitioner to so cause within so and so as to why registration certificate shall not be withdrawn or cancelled. Mentioned in therein tantamount to violation of section 28 of the Trade Union Act. My lord, this is not so much important. It is not furnished reply discussion held on so and so. Now, my lord, no action was initiated in pursuance to the notice of the so cause at so and so from 22/3/17 to 19/3/19 for 2 years. No steps were initiated against the petitioner union. Now, 19/3/19, the response number 2, I notice dated 19/3/19 issued under section 10 of the Trade Union Act, intimated the petitioner union about the intention of the response number 2 to cancel and withdraw the registration certificate of the petitioner union. Being agreed by the issuance of the notice, the WPC so and so was preferred by letter the so and so notice was set aside and 2 months previous notice was to be given by the petitioner upon prior issuance of the cancellation of the registration certificate as under section 10 of the Trade Union. Now, this is the crux, my lord. Next one. Response number 2, by so called notice dated so and so issued under section 10C of the Trade Union Act. From here, my lord, the main thing comes. The petitioner union after received the so called notice by letter dated requested for issuance of documents relied upon while issuing so called notice dated so and so. Being agreed by the non-receipt of documents as the 2 months period mentioned in that so called notice about expire, WPC number so and so preferred by order dated so and so response number 2 was directed to furnish the requisite document to progress with the notice granting reasonable time to petitioner to file the reply. Now, 30/11/19. In pursuance of the order dated 15/11/19, the documents were furnished to the petitioner. Complaint, my lord, so dated 31/5/17 against the petitioner union filed after 4 years of obtaining the renaming of the registration certificate.
But
Enquiry
Mr.
report
Saivara, what I feel is that Mr. Das is right. Everything here which you have said
yes.
relates to a factual finding.
My lord, I'm coming. Whether it's a fraud, my lord, because I'm coming. Because they have said, my lord, it's a fraud. First thing, notice was issued under section 10C. 10C. Action has been taken, my lord, under 10B, which was pointed out by us in the second high court order, my lord. In spite of that, they have not changed that. Then, my lord,
But the power to, you see.
2 months time has not been granted after.
No, irrespective of use of 10B or 10C.
Yes.
The power to cancel is under section 10 only.
No, that is, I'm coming to that also, because that is the registration certificate. Here we have not issued get the registration. Registration is 78. They are not alleging anything against 78, 98 registration, my lord. They are alleging the change of name only. How they can cancel the registration itself, my lord? Suppose there is some irregularities in the change of name, my lord. They could have cancelled that, my lord, only. Change may not be allowed. Because there is no allegation so far our original registration is concerned. That is, my lord, on 2498. I shall place that, my lord. Then, my lord, after issuance of the documents, only about 1 month time has been granted. 2 months time not granted, my lord. That is further, 10 Deputy Secretary Government of Assam, my lord, addressed to Assam to stating that my lord, they had acted on the basis of the view of the judicial department. We say, prima facie, it's a case of fraud. Virtually, I shall come to that also, my lord. They have abdicated their power. Then again, my lord, certain documents were incomplete. We again sought for those documents. Then petitioner submitted the show cause reply. Then impugn order, my lord, came down. Now, my lord, your losses may come to the so-called notice itself. I'm not going to. First, my lord, page 91. Your lordship, what is, my lord?
Just a moment. Page
91. Annex 12, Roman 12.
yes.
Whereas the annual return of oil and gas employees union, Juliajan, for the year ending so and so, was being audited by the senior assistant supervisor and authorized person as per provisions of my lord. Well, this may be given out because this is not the ground for litigation. Second para. Whereas on receipt of complaint from the Indian Workers Union, Juliajan regarding forgery committed by the showing the presence of retired dead employees in the general meeting dated 11/5/13, in which all technical workers union changed to name of the oil and gas employee union. An inquiry was concluded by Assistant Labor Commissioner, Dibrugarh, Labor Officer, Dibrugarh, on 30/10/18. During their inquiry process, 11 persons were present out of 27 names submitted by the complainant union of the general meeting held on so and so. In the individual statements, 11 persons denied their participation in the general meeting held on so and so. 3 and 4 persons already expired. The inquiry report reflects that the union has forged the signature of putting the name of the person who had not attended the meeting and some persons who has already expired. Therefore, so and so, the short and views of receipt from the judicial department was forwarded to this end from the Labor Welfare Department, Government of Assam, which states that there appears to be some fraud on the part of the union. In this context, the Registrar of the Trade Union Assam may take action under Section 10B of the Trade Union Act. Therefore, in my capacity as Registrar of the Trade Union Assam, you are hereby called upon to show cause as to why 2 months, within 2 months from the date of issue of this letter, certificate of registration shall not be withdrawn or cancelled as above 10C of the Act. This is the my lord. Now we sought for documents. Documents were not given. Then we approached this honorable court. Your losses may just see, my lord, page 97. We have approached this honorable court, and we have pointed it out, my lord. At page 98. The read petition has been filed assailing the notice. At page 98, my lord, the order may be.
Yes.
The petitioner has filed assailing the notice issued by respondent 2 under Section 10C of the so and so submitted, besides being contravention of provisions of the contained in the extension, the impugn notice also held that on account of fact that copies of complaint and relevant documents had not been furnished till that. Submits that there is no allegation of the meaning of section 10C of the act. The impugn so called therefore proceeding are liable to be set aside by the county. Now this has been pointed out at the initial stage itself, but they have not changed it. Then, my lord, by page 100, annexure 15, they have supplied some copies on 13/11/2019. And we were asked to submit the so-called, my lord, by 31st December. Actually, no 2 months time has been granted, my lord. Ultimately, my lord, the so-called was submitted, and the response number 3, he passed the impugn order. My lord, here one thing I am supposed to say, my lord, the response number 3 is so biased that immediately after passing the order, he filed KBS for the courts in his personal capacity. I have annexed it, my lord, at 142. In his personal capacity, my lord, he has filed KBS before his court. I do not know, my lord, he is the authority, why he is so interested, my lord. 142, that's a KBS, my lord. (142) and he has also filed for the labor court at page 146. I do not understand why he is so interested. Oh, by a stage. So now it's a place the impugn order, my lord. Impugn order is at page 139, my lord. I shall not go to the other text, my lord, because I shall not waste much time. Even impugn order, my lord, I may place the findings also. Findings itself, that will be. Which is at page 140, my lord. Because on 2 grounds, my lord, that some of the persons joined in the meeting, but 300 persons were there. Some were there, some were not there, other things, my lord, 27 persons. Whether that tantamount to fraud, my lord. Actually, my lord, he has given more stress to the views of the judicial department, where he said it appears to be from case of fraud. That's all. If you also see findings at page 140.
140?
140, my lord.
140.
Huh?
140.
140. 139 is the impugn order begins. The text has been given here. Then findings, my lord. After going through all the facts and materials in hand, it is found that out of 27 persons employed names in the original complaint filed by Indian Oil Workers Union, which are derived from the records of the general meeting proceeding of the Oil and Gas Employed Union, 4 persons had already expired, 8 persons have retired, 1 was posted at Kolkata, 1 person was non-worker, 1 person was an executive, not related to Workers Union, and 1 person remained absent as per inquiry report received from the Assistant Labour Commissioner Dibrugarh. From the remaining 11 members, 8 individual members did not match with the ID numbers written against the names listed in the original complaint. In the inquiry report, 11 numbers of participation shown present. The general meeting has deposed statements before the inquiry committee, wherein they have denied their participation held on 11/5/13. However, in response to the above findings, so-called replies submitted by Oil and Gas Employees Union has not stated anything. Well, I shall place that my statement. This is absolutely perverse. Has not stated anything, though copies of the report were also furnished to them. Therefore, the union remains silent about the main allegation of fraud made against it. Well, some person suppose appeared and signed on somebody's behalf, can it appear to be a allegation of fraud, my lord? The report revealed that management as well as members present in the inquiry process conducted by external level poster Dibrugarh had stated that there is no auditorium of OIWA and they were not aware if such meeting was conducted on so and so elsewhere, anywhere else. This is also perverse, my lord, because we have not said that auditorium OIA, office of the OIA. And permission was taken from the police station. I have annexed that also. In the office of the OIA. My lord. After going through the records, it is also found that trade union, oil and gas employees union is trying to take a plea, the letter bearing number so and so, submitted by the labor officer Dibrugarh without giving a specific reply to a so-called notice. The letter itself expresses that verification was done on the basis of the original records of the union placed before him, and no specific complaint was received at that point of time. The specific line derived from the letter is as follows. In inviting reference to a subject cited above, I want to state that after verification of the original records of the union may be so and so. But this is the original inquiry, my lord, made by on the basis of which my lord name was changed. In the second paragraph, page 20, so-called reply, that so and so submitted by oil and gas employees union. The trade union has admitted that they have made a mistake. However, in defense, they have stated that same is bona fide in mistake on the part of the members while recording their membership details. The acts of the trade union, oil and gas employee union cannot be taken as a bona fide inadvertent mistake, as they have listed the name of the dead persons, absent persons, person who were retired, etc., to get the name of the trade union changed from technical workers union to oil and gas employees union, which is an act of fraud. The malafide intention of the trade union also be ascertained from the fact that they have taken permission from the Dhuliajan police station on 6/5/13 for the auditorium to conduct the general meeting. This is also perverse, my lord. No auditorium, this is office, my lord. There is no sufficient proof that they are actually conducted the report of the external letter. Further, in the so-called reply, that the so and so oil and gas employees union has raised the question that 5 years gap period in filing the complaint of the Indian Oil Workers Union. However, the same is not acceptable as the allegation is regarding fraud. As per records, it is revealed that annual return for the year ending so and so was initially audited by senior treasurer and was further duly audited by chartered accountant only after so-called so and so. So this is not the technical workers union. This is the 40%. Registered versus so and so changed its name in the general meeting at 11/5/13, where some participants are whether expired retired workers posted in Calcutta under the tax and sanctions mentioned above, that ascertained that oil and gas employees union had malafide intention. It is well established that trade union of the oil and gas employees has committed fraud in obtaining the rename of the registration certificate. And the views of the judicial department is very specific. The said union has violated 10B of the Trade Union Act. Hence, the certificate of registration in the name of the oil and gas employees union is liable to be cancelled. Provision of the so and so. Now, my lord, I shall place, my lord, what they have said that we have not replied to, my lord, because in the second paragraph of the findings, your losses may come to page 131, my lord, of our reply. How perverse it is.
Page?
Page 131. The reply begins earlier, but I am not, the reply is not necessary because that perversity I am showing. Page 131.
But this one, Mr. Das is right. Everything is factual.
Well, whether it's a fraud. Well, first thing. Second thing, whether our original registration can be cancelled. Well, we have changed the name. Name.
No, but
change.
the question is, you see, number one, if the order is incorrect,
Well,
then there is an appellate authority. That is one. And second is assuming that that I hold that the finding of fraud is wrong.
Yes.
Then what I do is that I'll have to send it back to the union for before the authority for re-adjudication.
well,
But as a
that-
writ court,
that
I
is the
can't,
only allegation, my lord.
labor dispute, I can't settle
Well,
here.
that is the only allegation, my lord. If it is not fraud, it
No, but
cannot be, my lord,
what should the court do in a writ petition?
my lord.
But what should the court do in a writ petition? Can I decide a labor dispute here?
Yes,
in a writ petition. That is something which
My
I will not be able to do.
my lord, your losses may see 10B, my lord.
No, we take it that you are right. Absolutely everything is you are saying is
And-
right.
And
But then what do I do? In a writ petition, what is the remedy which I can give? To what extent?
my lord, if your losses see, my lord, the rest, if 10B, my lord, just the losses may see, my lord.
No, for a moment, I'm not saying that you are wrong.
My lord.
Assuming that you're right in all
So,
aspects.
It is the original registration, my lord. Now, here, my lord, 10B, 10 deals with the registration of the original registration certificate. Whereas, my lord, your losses may come to section 25 and 26. That is the change of name. Twenty-five. Notice of the change of name or amalgamation. Notice in writing of the every change of name and every amalgamation signed in case of change of name by secretary and 7 members to union changing its name. In case of amalgamation, so and so, so and so. Party there to send to a register to a local head office. So and so. If it is proposed, the name is identical, which any other existing trade union has been registered or in the opinion of register so nearly resembles such name likely to deceive the public or the members of the either trade union, register may refuse the registerment, change of name. Hereby provided a substance to register shall, if he is satisfied, the provisions of the act in respect of change of name had been complied with, and register change the name of the registered apartment section 8, change the name shall have effect from the date of registration. So it is the my lord, section 25, my lord, the change is takes place. Now, my lord, suppose change has something wrong, my lord. The change may be, my lord, original cannot go, my lord. Original registration, there is no fraud, my lord. Section 10 deals with the original registration, my lord. And so far,
Where is the notice given to you?
my lord?
Where is the notice given to you?
Yes. Notice, my lord. Page 91, one, my lord. Page 91 with the notes. Second para, my lord, first para, they have not taken it. Second para. And they are giving more stress on the judicial department's that letter. That is at 108. It says, because the privacy, there appears to be some fraud on the part of it. This is the only.
The impugn order is at page.
Impugn order is at page, my lord,
139.
139. Mainly two allegations, my lord. One is regarding the meeting in the OYS auditorium, they have said, what we say office, and 27 members not attended. This is the
Yes.
only- Whereas 300 members attended the meeting. If your lawsuit come to 152 page, their report itself is wrong, my lord. This is the permission from the officer in charge. With regard to the technical workers union central so and so, then we like to inform you that general meeting of the union going to be held on so and so OIWA office. We never say my lord auditorium. And they said that there is no auditorium. We have not said so. Auditorium office. OIWA. Perversity is here, my lord. Absolute perversity. And for I can place several decisions of Supreme Court, my lord. How, what can be established? Can it be a fraud, my lord? Some persons fake names supposed to attended a meeting and put their signatures on their name. Many wrong voters has, my lord, given, my lord. Dead name voters are casting their votes, my lord, many times. List is not, my lord. Can it be a fraud, my lord? And there is, my lord, there.
No, you see, the perspective changes. The question is that when a statutory appeal is provided for, let us say for an example, let us say a check bouncing case.
Yes.
Against the order of conviction, appeal is provided for. Say for us, for example, a suit against a decree passed, there is an appeal provided for.
Yes.
Now let us assume that the orders passed are absolutely illegal in the check bouncing case or in a suit. But can in a writ petition I open the factual matrix and then start adjudication?
No, my submission is this, my lord. I shall place one judgment of the Supreme Court also in this regard. Because first thing, notice itself is wrong, my lord. It is given under 10C.
No.
Sec-
In fact, in your notice somewhere it is written that it can also be converted into 10B.
Well, that is one aspect. Secondly, my lord, from the date of service of the documents, my lord, 2 months' time has not been counted.
Labor Commissioner.
Second.
has given
Third,
an
my lord.
affidavit. Labor Commissioner has filed an affidavit. Wherein, my lord, he has said. that-
Labor Commissioner, I think he should be more silent.
No, I'm not the labor commissioner. They have filed, I'm not the OL, my lord.
Okay.
They filed an affidavit, wherein, my lord, they have said that this is a typography.
Because once a caveat is filed by the Labor Commissioner, it speaks large.
That's different.
Stake is not.
Adjudicatory authority passes an order and then files a caveat.
Give his own name.
Nothing.
My lord, I am the, my lord, we are the OL. Now, today we have to go with, the problem with us is, if we go ahead with the election, allow the petitioner to also participate. Tomorrow, my lord, it's only a stay. And my lord, the stay is vacated and the petition is dismissed. The whole exercise goes. That's the only worry I have. So, my lord, section 11 is a statutory provision. It flows from that. It has to be an appeal. Let him file
No,
an
but
appeal within a particular period
what
of time.
Mr. Saiwala is suggesting, the presentation which Mr. Saiwala is making,
Lordship.
I think this matter has to go back to the original authority, the Labor Commissioner.
Then, my lord, we'll have to come to a conclusion that my lord, only on the 10C part.
There are three things, in fact.
Lordship.
10
B and 10C.
10B, it is
It's
converted
under
into 10B. Correct. There is
And
one
Lordship,
part.
One factor, they had assailed that before this honorable court.
And this court sent it back.
So this court, my lord, said that the only matter was brought down to the fact that they were not given the documents. The documents were subsequently given. The direction is, my lord, in the first part of the order, it says 10C. Thereafter, my lord, it was not gone into. Then, my lord, the documents were given. Thereafter, my lord, after the inquiry, the notice that was given under 10B. And finally, he
where is that?
replied to that.
Where is that?
Yes, it's it.
And the second part, why I intend to send it back to the same authority, is the issue of fraud.
Lordship.
You see, when somebody is declaring something a fraud,
Lordship.
they have to show something more.
And on that, if your lordship wants to decide on merits, well,
No, it's not a question of merit. It's a question of whether I take it up or I don't take it up,
My
but
lord,
I'll have to,
108.
but I'll have to say something.
Yes. Yes, my lord, if your lordship is sending the matter to the original adjudicating authority, my lord, then the matter will be different because your lordship will have to say something on merit.
Yes.
But if your lordship sends the matter to the appellate authority, things
No,
are
because
different.
you see, the reason is that somebody is losing a forum. If, say, for example, the adjudication on the fraud,
Yes,
that requires some more evidence to be gone into it. It can't be decided like this.
yes.
So if in the original, if in the original trial, the issue of fraud is not taken up in a appropriate manner, then in appeal it can't be rectified.
Well, the report, the impugn order says the report given, they did not reply to the report. They
It's
did not
okay.
give any comment.
No,
to it.
no, but still, without evidence, without anything, can it be a fraud?
But they did not reply to it. This is what
I
the
understand.
paragraph says. Ma'am.
You see, in a suit, you
This is a-
defendant.
whether your
No, it's
lordship-
okay.
this is a,
But somebody appears and doesn't file a written statement. But still under 10 even the decree is passed. Some merit has to be gone into.
But here, my lord, the inquiry report was there, they did not reply to it. They did not deny, they did not reply to it, and therefore, my lord, the conclusion has come that
Page
the,
111 is the inquiry.
yes.
No, can fraud be declared merely because somebody is silent?
No,
No,
because they did not,
That is an
it is-
inquiry done by hearing him. He was also heard. Thereafter, my lord, he did not challenge this.
they did not show that they were present and all those persons who were present there, they are
But they-
alive.
You see, come to page 108 again. Who is the adjudicating authority?
My lord, this is the government. The government who has, my lord, said that judicial department's view was taken on the report. and
No, but
said
who is
that
the
you can-
who is the adjudicating authority?
It's the, my lord, the
Labor Commissioner.
Labor Commission. Labor Commission.
Labor Commissioner.
This is
So you
my
see-
lord,
So you see, Labor Commissioner does not issue a notice under 10B.
He had.
He had issued a notice under 10C. And then the superior authority says, now you proceed under 10B.
Gotcha.
But notice under 10B was never issued.
But the subsequent thing that was issued, that was persons to that letter, they have, my lord, given a detailed submission.
No, no. I'm still, I know, you see, I'm still not finished with, no, I'm still not finished with 108. What,
Gotcha.
you see, Mr. Nair,
Gotcha.
what happens if before any authority, I send the matter back? You think of any case it occurs to you?
It's for all India,
Which-
my lord.
No, no.
Really nothing.
I
No,
have
no.
nothing.
No, not that. You think of any litigation.
Gotcha.
Think of any litigation.
Gotcha.
Which litigation?
My lord, a civil suit would be a better place here.
Civil suit.
Gotcha.
Okay. In a civil suit, if I give as a high court, if I give a finding, there are ingredients of fraud available, and therefore now you decide. And you are the defendant in this suit.
I got it.
Correct?
Here the issue is a little bit different.
No. You see here what it says.
My lord,
There are ingredients of fraud, and then 10B
I
you
can't
decide.
take sides here.
No,
can't
it's not-
take
no.
neither the petition
No,
nor the
no.
response. But
I
one
just
thing, my lord, will note, the projection that is being made before my lord is, there appears to be what's falling from my lord is one thing. But what was being projected all along was that you are just presuming some fraud.
Hmm.
You're only presuming,
Hmm.
there's nothing.
Hmm.
But my lord, what had happened here is right, wrong, there is an order, right, wrong. There is an order. If this order can be essayed, because my lord, it goes back to the disciplinary authority, the original authority also. These grounds can also, the appellate authority, these grounds can be taken before the authority. It will be a very good case for an appeal, my lord. If these are the lacunas in the order, this would be a very good case for them, my lord. And my
and-
thing is, my lord, I want a shorter
No, and-
adjudication process.
no, it's okay. But what happens if that issue of fraud
Lordship.
remains intact in the trial court?
So fraud, my lord, can always be dispelled. In an appeal, that fraud, what they have to do? Number of persons, 11, my lord, say, X, he is not there, dead. So that's the reason, my lord, they said it's fraud,
No.
and there is no meeting.
So far as I understand, subject to how you convince me is another. What I understand is that a plea must always be first taken up in the adjudicatory,
But that's a
first.
lacuna on their part. That's a lacuna on their part. Now they are trying to remedify that, my lord, by coming before you.
Just,
My only
just,
problem-
just. Okay. Yes.
My lord, my only fear, my lord, is that by going back to the original authority, the process will get elongated. We are not in a position to hold the election still, because we don't know if we allow him to participate, no problem. But tomorrow, my lord, this cancellation stands, then the whole edifice of that election goes wrong. If the laborers would suffer.
Question of participation doesn't arise.
Okay,
The
no,
lordship is deciding the
No,
matter.
no, I'm not that, I'm not. So, my lord, a finality in this matter is required. Either my lord will take it up for final disposal, consider the issues, and come to a conclusion, or my lord, the statutory remedy that is available on any count, statutory remedy that is available, he'll go there. Now, my lord, if there are materials available with them in their original thing, whatever allegation has come, basing them, my lord, they can always dispel those. They have the materials now. In the appeal memo, they can take all those things. And therein, if the authority is satisfied, the authority can pass any order. You can set aside that order, remand back, whatever happens, happens. And there is an interim order operating. My lord will maintain that interim order. My lord will maintain that interim order in the meantime. Otherwise, my lord, disputed questions will have to be gone.
Before the labor, this labor authority, adjudicating authority, which is the labor commissioner. What is the procedure prescribed? Evidence is taken? No.
It's a summary nature of proceedings.
Summary nature. Now, in a trial which is proceeded summarily, what according to you is the procedure to be followed in an appeal?
My lord, in an appeal, as far as I've understood, there is a finding against you. That, what is the finding? Well, let's forget fraud for the fraud is an inference. The ingredient is my lord, that these number of people whom you have projected to be present in an auditorium on a present day.
Auditorium, it doesn't say.
Yes, it's in the inquiry report, there is an auditorium. There is no auditorium otherwise available. So these people are dead. Or these people were never members, or these people are non-members.
No, my original house
Lordship.
is a 3-room flat. I always call it a castle.
My lord, it's interpretation.
So,
No,
so
what I'm
therefore,
trying to, I'm not on that.
Hmm.
What I'm trying to say is that they have held a meeting on a particular day in a particular place with a particular number of people. They'll have to establish that only, my lord. The allegation is that the people you are projecting are not the persons. either debt or, that's the only thing they have to dispel. My senior my lord has to dispel only that point. And I don't find anything material available to dispel that much. If that is dispelled, everything falls back. Fraud is also gone, everything is gone. If it cannot be dispelled, mere my lord will not go by the word fraud. My lord will see how the fraud is being input. This is what is to be put. That's why I said, my lord, subject to what my lord would finally say, let the matter go back. Let there be a decision there within a time frame. My lord will maintain the interim directions.
No, because when you say fraud, I recollect your argument in that APSC matter.
That was a different book.
No, no.
Setback law.
Memory is not short.
My lord. Photographing.
No, no, not that. But you remember your argument on fraud. So what is a fraud? What is a crime? What is
My only thing is tomorrow in the trial, if all those things get washed away, then my lord, maybe my arguments would have some substance.
no, definitely you appear to be very strongly arguing that.
Because only on the basis of a material collected under 161, I'll just use that 161, one of preliminary investigation you do it. And
No, I'm in the context of this, not on this.
Your memo would come to section 11(3). Or say 11(2).
A suit, same procedure.
11(2). Appeal, the procedure is in 2 and 3.
3 is as per suit.
Suit one. And my lord.
So evidence can be taken.
the
Evidence
appellate-
can be taken.
This can be. The appellate court may dismiss the appeal or pass an order directing the registrar to register the union or to issue a certificate register after the provision so and so, setting aside the order of withdrawal of cancellation of so and so, as the case may be, and the registrar shall comply with such. For the purpose of an appeal under subsection 1, an appellate court shall, so far as may be, follow the same procedure and have the same powers as it follows and has when trying a suit under
No,
code
that's
of-
what I said.
So, my lord, everything is there, my lord. Let it go back on 11.
Yes, Mrs. Saiwala.
My lord.
You have to delegate you back to the appeal. Uphold the objection of Mr. Das.
No, my lord, my assumption is this, my lord, that suppose, my lord, there is something so far, change of name is concerned, my lord. They could have
Pardon me?
change of name. Because there is no allegation, so far my original registration is concerned.
No, whatever be it, but you see, even in 10C notice, they are referring to 10B.
Hello?
And 10B, the registration has cancelled.
Yes. But, my lord,
So whatever be, anything else is going into the factual matrix.
My lord, first thing, my lord, they rely on the inquiry report, which is expertise inquiry report. Secondly, they rely on the, my lord, opinion of the judicial department in the impugned order also. Rough order, my lord. So, what they have said, and more of our perversity is there, but I said, that's why I want to press, my lord, that in the repression we have said so. What he has said, my lord, that is perverse. That is why, my lord, this education is, and moreover, it appears, my lord, the education authority is biased.
Mr. Saiwala, that's what I am saying. You are 100% right.
Yes.
But what should I do in the as a writ court? I can't substitute my view with the view expressed by the original adjudicating authority. I've got the powers would be akin to one of revision. Number one, I can set aside the finding and send the matter back.
My lord.
And number two, the appeal is the only way
My
to
lord,
adjudicate. But I can't substitute my own view.
no, my humble
However-
suggestion is this, my lord, because it is this matter, requires only to be sent it back, my lord, because first thing, he has not considered that whether the modification is to be cancelled. Suppose something is there. Secondly, the so-called notice was wrong under 10C. Thirdly, my lord, proper time has not been granted. And this auditorium matter also I have shown, my lord, to your lordship, that is perverse. And the other finding is also perverse, that we have not said anything. That is also perverse. He has to consider the aspects, my lord, because in the SOCOS, we have given the detailed SOCOS has been given. We have shown everything. Page 131, that is why I want to place, my lord.
Where is that report?
My lord,
Where is that report?
report. Yes, and report is, my lord, at
111.
111.
I don't see one.
Let's see if we get those. But for another reason also, I am saying, my lord, that the authority, my lord, who has, my lord, he was biased. That appears, my lord, from the caveat files before this course.
That is true. He has proved that.
So that is why, my lord, the matter should be remanded back, because by this time, he might have changed, my lord, new person has
I
come.
think our caveat has proved his biasness.
My lord, that is so, my lord, he wanted to, my lord, put it, my lord, yeah, order.
Mr. Das,
I'll just point out one thing, my lord. Your lordship will kindly see page 140. I'll read these small paragraphs. If
I
you
am at
want,
140.
my lord,
I am at 140 and I was asking a question. Which
140.
was, yes.
So if somebody says, my lord, their names are false, he'll have to find out, he'll have to say this name is correct. It is the burden on his part. I'll just read it again, my lord. After going through all the facts and materials in hand, it is found that out of 27 persons, employee members, names in the original complaint filed by the Indian Oil Workers Unions, which are derived from the records of the general meeting, proceedings of Oil and Gas Employees Union, 4 persons had already expired. So if these persons we have shown that these 4 persons are expired in the meeting, they'll have to say, no, it is not expired. They are here.
Exactly, that is what I am trying to come.
Yes, my lord.
Now you see, please come to 10B.
10B, yes.
Will that be a ground for cancellation of certificate?
Satisfaction.
No. Will that be a ground of cancellation of certificate?
No, that is a matter to be decided in appeal, my lord.
No, I understand. But Mr. Nair is convincing me to send it to the appellate authority.
I'm also saying, my lord, because
Now that's what I am asking you. You see the inquiry report.
Certificate has been obtained.
You see the
before.
inquiry report, you see the order at page 139 and then 10B.
10B, by fraud or mistake.
A stand taken by the petitioner before the Labour Commission at 134 second paragraph.
No, it's okay.
No,
Just
same point which my lord is trying to argue. Well, my lord is trying to
question.
My lord. My lord is trying to question that second paragraph. My lord will just have it because there are 2 words used here. Has been obtained by fraud or mistake. Fraud or mistake.
No. You see, fraud number 1. So far as I understand from the inquiry report, conjointly read with page 139 order, is that the fraud is the element of fraud is ingrained in the fact that some false people were there in the meeting. Correct?
It is their burden.
No, it's okay. It's their burden. Mr. Savala has failed.
Failed.
Okay. Now under 10, can it be a ground to cancel registration?
That is 10 says.
Because my lord, the very change that was called for, subject to my lord, was the very change that was called for, the name change or whatever they were trying to say, that being based
No,
on
you see,
materials which is not
I'll tell you, today agreed by whatever I am saying. Let us say there is a lightning strike call by the Bar Association. Correct? This statement which I made is not palatable to the Bar Association. Immediately a lightning stand is taken to have a meeting and to boycott me for the time being. It's just a artificial story. Correct? Only an example. It may be horribly wrong, but it's still an example. Now the question is that in the meeting, 10 lawyers who were not present, their names are shown as present.
Yeah.
Correct. And so what the authority does is you cancel the name of the registration of the society.
That is not the provision of law in respect of Bar Association.
No,
This is a.
no, here it doesn't say that if the meeting is wrong, then Bar Association registration is cancelled.
Certificate of registration of a trade union may be withdrawn or cancelled if the registrar is satisfied that the certificate has been obtained by fraud or mistake.
Question of
But what I
certificate.
am saying, my lord, subject to, I am not going into all these things. What I am saying, what is wrong in him, my lord, filing an appeal against this, all these things, my lord, he can file an appeal. Why should this appellate forum be not, my lord, they will not go there? The same thing, my lord, the appellate forum, my lord, if they find that the whole, my lord, order.
Mr. Das, you see, I am asking a question for a particular reason.
Yes.
Number 1, Mr. Savala has raised the issue of perversity. Pitted against your. So you see, if the finding is perverse, then it doesn't go for appeal.
I don't see any perversity in the findings.
It goes back to the adjudicating authority, number 1.
If I may just read it again, my lord, this paragraph 39 again.
Yes,
139, 140, 140. My lord, if I say perversity will happen when? If I say from the record, these 4 persons have been shown wrongly, and he says, no, these 4 persons are very much there, these are their identity, then this will be a perversity. But here, what has happened, Malad, the union has changed his name also. If they said wrong, then
You know,
they will have to show that
I'll just give an example, Mr. Das. In Calcutta High Court, irrespective of the size of the court, they will always call it a court hall.
court hall, yes.
Correct? It's not a courtroom.
Right.
I am calling it a courtroom. A meeting is held, somebody will hold this, what you call the room to be a room. Somebody will say, this is my auditorium. So can that be a ground that since there is no auditorium, it is fraud?
No, but this aspect of the matter has not come. Malad, I'm just reading this order. Malad, let me read, Malad. Records of the general meeting or so and so, 4 persons had already expired. So now if they want to say, Malad, that this is wrong, they will have to prove the presence of the 4 persons. This is one. 8 persons have retired. They will have to show, no, these 8 persons are working. On the face of it, here in the writ petition, this is how we plead, my lord. If the perversity is to be pleaded, they just said wrongly. On the face of it, I have given show cause reply, and in the reply, I have shown these 8 persons are in work. Then it says, my lord, one posted at Calcutta. Then how his presence is recorded here? He came here, or he was a member of the employee. In the writ petition also, he has not shown anything. In the before the adjudicating authority, he has not shown anything. Then he said, my lord, one person was a non-worker and one person was an executive and not related to any workers union, and one person remained absent as per inquiry report received from the Assistant Labour Commissioner Dibrugarh. So from the remaining 11 members, 8 individuals' ID numbers did not match. So these are very specific. If they want to say that perversity has been committed, all the records relating to this facts, they will have to produce before the court for the purpose of final decision by the court. Yes, perversity has been committed. And lastly, what it says, my lord, it says, my lord, the trade union has admitted they made a mistake. However, in defense, they have stated that the same is bona fide inadvertent mistake on the part of the members of the members while recording their membership details. The acts of the trade union, that is oil and gas union, cannot be taken as a bona fide individual inadvertent mistake, as they have listed the name of the dead person, absent persons. So they will have to say that this perversity has been committed by the adjudicating officers, showing that they no, this is not dead person, they are alive persons. Then absent person, this is not the absent person, they are there. Persons who are retired, etc., to get the name of the union. Trade union changed. Again, name of the trade union changed from Technical Workers Union to Oil and Gas Employees Union, which is an act of fraud. So name also has been changed. So in order to, my lord, show that they have committed perversity, my lord, they will have to show it that no, we have not changed the name. These persons are not dead. Why? They are not dead. This is their passport. They have some documents they will have to show that they are alive. Then your lordship may say that they have committed perversity. So therefore, with all these allegations, there is an appellate authority before as per the statutory appeal. Why should they not go there? And it has been lying here for a very, I think, from 2-3 years.
Still we are early. We are now hearing items of 2009 and nobody is appearing.
But we are appearing, my lord.
No, that's okay.
We are appearing. So
I'm not
my
talking
lord,
of an individual.
on the face
I'm
of it,
talking
my
of.
lord, sir, I'm not saying anything. Let it go to the appellate authority. Your lordship will protect their rights. I'm not saying that cancellation will be. Interim order is there. The protection will continue. Your lordship will direct the labor commissioner because he will get a better chance. That's what my learned friend was showing. 10, 11-3.
11-3.
Yes, my lord.
Procedure of suits.
Detailed opportunity will be given, my lord, for the purpose of appeal, because this is a summary proceeding before the adjudicating authority. But before the labor commissioner, before the appellate authority, for the purpose of an appeal under subsection so the appellate court shall, so far as may be, follow the same procedure and have the same powers as it follows and has when trying a suit under CPC CPC and may direct by whom the whole or any part of the cost of the appeal shall be paid. So
Mr.
procedure.
Nair, you were referring to which page?
page?
134.
Yes.
My lord, what I'm trying to say is.
So let it go
No,
back.
you are
to
referring
separate.
to-
Already placed that.
Page 1.
134. Why I was not going to. My senior has already placed. That's what I was trying to convey. The allegation is that you held a meeting of the union. And that union represented before the labor commissioner. That when basing on this meeting, this is the decision arrived, change the name. Now, my lord, it was found that the meeting itself is doubtful. Because the persons who were there were not members or dead or absent. This fact is yet to be proved, my lord, to come to the conclusion of purpose. And in para 134, second paragraph. they say-
Where I have read, I don't know. Where I have read, I don't know. But and how did I recollect? I am not recollecting that also, I don't know. There was a case of two labor people who were wanting a transfer from place A to place B, which is not permissible. Then the management has a grudge against the particular office bearer of that union. So now the employee who wants transfer, they come to the management, says that please give me a transfer. The management says, okay, well, there's a meeting which is going to be held of your union. Go and bash up your secretary and I'll transfer you. Now, this secretary in this meeting is bashed up, comes to the management and management sends him on punishment transfer. Correct. So everybody is happy. Now I am asking you, in this labor union, how do you profit out of it?
My lord, my question is different. I am facing a different problem. I have to hold the elections now. There is pressure on me. I want this thing resolved at the earliest. Because I cannot go to elections without him. Until and unless this is, my lord, in a cloud. If he clears that cloud, nothing like it. The people will have choices.
Is for management, my lord.
That's what I said. I
My
want
lord,
that.
That's why I'm telling a story and asking him, what is your interest?
My interest is, my lord, this matter should be clear at the earliest. Either his cancellation should be upheld or his cancellation should be, my lord, declared null and void.
Okay.
my lord,
And he
what,
should be given his certificate so that the elections can, my lord, the matters came up. It went to the commission, came to us, my lord, came to me. I had to give an opinion. They wanted to hold, they don't want to hold the meeting. I said,
It was,
file an
it
IA
was-
and get this matter heard here. They
okay.
were with us for a long time.
my lord, why, sorry, the,
Majority union for a long time.
the executive authority has said, we have said nothing, my lord. No, in the so-called,
No,
Yeah.
I'm just trying to have it resolved.
yes,
Uh,
my lord. That
Okay.
is why I am saying, my lord, this is a matter where it should go back to the original authority, my lord.
Okay, I'll
Because he has
take a
not
decision
considered
and-
my so-called, my lord.
I'll take a
Because I
decision
can
and
place
call,
my 2-3
come
breakers.
back. Monday for delivery orders. Saturday, Sunday, let me burn some oil.
Besides, let there be a time frame.
Time frame to a court I can't give.
No, my lord, because my lord will observe, because otherwise, my lord, this thing elongates, I'll be in trouble. My industrial relationship will be in trouble.
No, because this is a labor court, industrial tribunal. It's going to an industrial tribunal.
Yes.
Industrial tribunals, I can't
Always say
Can,
that
my lord, expeditious. thing.
expeditious.
expeditious, but I can't give.
They
a
have
time.
no work, Palo. They have no work. They will do it immediately. They have very less work, Palo.
No, there's a different issue altogether.
That
There are 3 labor courts,
in the
out of which incidentally I met 2 judicial officers of two courts. And they are saying no, I am Mr. Yes, your name, who was there for Mr. Roy?
Chaudhary, Jyotirmoy.
Your name?
And I, yeah.
And
Nilofer.
Actually, I was.
Second name?
And
Ahmed. Counsel appears on behalf of Mr. J. Roy, counsel for respondent number, senior counsel for respondent numbers 1 to 4. Mr. Biridas, Learned senior, next para, Mr. Biridas, Learned senior counsel for respondent number 7, and Mr. UK Nair, Learned senior counsel. Just write one more thing. Mr. Das, senior counsel, assisted with Ms. Ardeka, counsel for respondent numbers 7, and Mr. UK Nair, senior counsel, assisted by Mr. K. Kalita, counsel for respondent numbers 5
and 6.
6 and 6. Raise a preliminary issue of maintainability on account of alternative remedy provided under section 11 of the Trade Unions Act. Next para, heard both sides on the preliminary issue raised.
Well,
Next.
I put even the list of books also along with the. Should I?
Next para,
submit
the
the copy of the judgment?
learned, no, not required. The learned senior counsel for the next para, the learned senior counsel for the petitioners has given a list of dates along with a list of citations on which he is relying on. The same is kept as a part of the record. Next para, list on Monday 24 for delivery orders.
Well, these citations I just given.
Pardon me?
Photocopies are given. Photocopy.
Judgments, okay. After the order, Mr. Savala, you can ask your, after the order, you can ask your instructing counsel to take it back because we don't have any use for that.
But these are Xerox copies only.
No, because we otherwise throw it away unnecessarily.
Yes, madam. Yes.
Yes.
May I please, your lordship?
Yes.
My lord, this interlocutory application is moved, my lord, in connection with the election petition 1, my lord. What has happened, my lord, the respondent number 4, my lord.
4 has died.
have
Any
died, my lord.
objection?
We have annexed a certificate of his death, my lord. That is
Any objection by anyone? No.
My lord.
Any objection?
Lord, we have informed, my lord, even we have served copies to them also, my lord.
Okay. Number 4 has died.
My lord, number 4 has died, my lord. Even in the election petition, he is unrepresented till date, my lord. He has not appeared, my lord. Despite service of notice, my lord.
Okay. The heard Mr. A.R. Bhuya, Learned counsel representing the opposite party number 4.
No, my lord, I am for the election petitioner, my lord. The election petitioner has preferred this I am, my lord, as an applicant.
Appearing for the applicant.
My lord.
Full stop. The applicant is the election petitioner in the present, in the connected case. Next para. This interlocutory application has been filed for striking out the name of respondent number 4 in the connected election petition on the ground that he has expired on.
My lord, he has expired on, my lord, date of death is 19/7/2022, my lord.
19/7/2022. Full stop. Next para. It is also submitted that the respondent the respondent number 4 in the connected election petition has remained unrepresented.
Unrepresented.
Next para. On the ground that the respondent number 4 in the connected election petition has expired, comma. The court is inclined to allow this application and the name of respondent number 4 in the connected election petition stands struck off
My lord.
and deleted. Next para. This interlocutory application stands allowed. And in the election petition, you will have to write. For Mr. A.R. Bhuya, counsel for the petitioner, and Mr. A. Barua, counsel for respondent number 1.
1 minute, please.
Next, in view of order passed today in IA Civil 1941 of 2023, the registry shall strike out the name of respondent number 4.
Anwar Hussain, Laskar.
Next para. This will be a written statement.
No, my lord, actually the
Oh, this,
proceeding is state, my lord,
okay, next
that's why.
para. As the
There is already an
proceedings
order till-
has been stayed by the Supreme Court of India,
Apex
this
Court.
matter stands adjourned, stand aside.
Obliged.
Production list item number 1.
But junior years made the correction, mala, I don't know how she has done it anyway.
Heard, Mr. R.P. Sharma, Senior Counsel, assisted by Mr.
P Teli
P.K.
or Fulla Teli.
Oh, P. Teli, counsel for the applicant. Next para. This interlocutory application has been filed for correction of the cost title of the petitioner
Yes.
in the connected BA 1204 of 2023, which was disposed of by order dated 13/7/2023. Full stop. Next, it is projected that the applicant is the son of Matleb Ali, right?
Matleb Ali.
MATLEB, Matleb Ali. Full stop. However, comma, due to inadvertence,
His mother's name was
instead of the name of the father, comma, the mother's name was reflected as is reflected in the cost title. And the applicant is shown to be son of Rohima Begum, Rahima Begum, whereas he is the son of Matleb Ali.
My Begum is mother anyway.
Next, accordingly, this interlocutory application stands allowed. Now you write the next para. In view of this application being allowed, comma, the registry shall make necessary correction in the cost title of BA 1204 of 2023 to insert the name of SO S obligo Matleb Ali, MATLEB, Matleb Ali, in place of inverted commas, yes, SO Rohima Begum. Next para. The you'll have to redeposit your certified copy.
I have not taken it. Oh, I have not taken.
Huh? No, certificate copy has been taken.
Yes, will deposit.
You'll have to return it back. Next, accordingly, on the counsel of the learned counsel for the petitioner, returning back the certificate copy, comma, the registry shall issue a fresh certified copy with the corrected cost title in respect of the name of father of the petitioner. Application stands allowed. Application disposed of.
Two.
Please, your lordship. So the petitioner was elected as a president, my lord, of the Jalorshore Noyangaon Gaon Panchayat, my lord.
No, ask the counsel for PNRD to be here.
My lord,
I've already informed, but they're.
No,
not
just
available.
ensure his presence. I'm not taking up ex parte matters. Just inform them. 2, 3, same.
Mm. 11 and 12 for hearing.
I thought, my lord, I will be lucky today, but it seems that.
You are,
Yeah.
you at least have an audience.
Lucky in the sense that the matter has been called, but to what extent, my lord, it will be fruitful. I
No, I
don't
don't
know,
know. You see, I have an experience
my lord.
when the matter is not also taken up.
Lawyers can be,
No, senior counsel make it a habit in one particular court to just say that your lordship is adjourning it. Yes, okay, well, good.
my lord, these things may work outside, but in Guwahati, my lord, of late, it doesn't really work much.
No, no, good
More
things
so, my
can
lord,
be.
these are the days of live streaming.
No, no,
So
good
all are
things,
wiser.
good things can be incorporated always. It is always welcome. Whether you like it or not, good things are there to remain.
That's it.
Yes,
Lordship, in this matter, I've been led by senior counsel, Mr.
it is
K.
already been partly heard.
Partly heard, Lordship.
Yes.
Now, he was prepared, suddenly he had to go after the break, therefore.
No, but then we'll close that and we'll permit you to file your written argument.
So, my lord, in that case, I can start at least.
You file your written argument because you see, otherwise I'll have to release this matter from being parted.
That may not be done, my lord,
No,
because
no.
matter has already
No,
been
no,
heard
because no, no.
substantially.
You see, if Mr. K. Chaudhary has something to say, if I'm stopping him from argument, that would be another.
They always have a right to reply.
Yes, what do you say?
In reply, they may place everything.
Only some parties left because
No, but you see, parted matters, I can't do anything. Either I'll take it up or I'll have to recuse myself.
Because, my lord, in my case, I'm reasonably sure, my lord, because I will not be able to conclude my argument today if I start. That is true. I won't be able to conclude. Whatever little time is left, if I start.
Okay, then he may in his reply, he may add those arguments.
Yes.
Whatever is left out can be added in the argument later stage.
But I'll try to just refresh if possible.
No, not required. Refreshing, I have my notes. Refreshing is not required.
Then if senior counsel wants to start, I can't have an objection.
Yes.
No, my lord, I begin. Please. Thank you.
You make it concise so that it can be concluded, your part.
They will get a chance. I won't be able to conclude my arguments today.
You have to, you have to.
My lord, I'll try my best, but my lord.
No, you'll have to squeeze it. Because
Lord,
it's
even
a
if I make my argument very short, anyways.
Hmm.
My lord, there are two fundamental principles. I'll be pressing.
You're for?
My lord, I am for the NHPC, the respondent number in this case. Respondent number 2, 3, 4, 5. 2, 3, 4, and 5. That is WPC number 118 of 2023. GLT Construction Private Limited. Union of India has been made a party, but they hardly have any role to play.
Yes.
So, I am appealing for respondent 2 to 5. The private respondent, Brahmaputra Infrastructure, they received the notice, they have chosen not to appear. Because practically they have no say in the matter It is the decision of NSPC which is under challenge. Now, my lord, while processing this very issue of NIT, the two fundamental principles, my lord, which NSPC borne in mind, namely the level playing field and the free and fair play in the joints. The submissions, my lord, which I am going to make, I will impress upon my lord that my lord will examine it from the perspective as to whether or not NSPC gave level playing field to everybody, number one, and number two, whether or not there has been free and fair play in the joints by NSPC. My submission would be that has been the case all throughout in the process. By sticking to this very particular principle, my lord, the effort of NSPC has been that there should be inclusion of bidders to the extent possible and not the exclusion. And for that, my lord, opportunities were given to the bidders to correct their defects. Now I'll come, my lord, to the sequence of events, which is going to be very relevant. My lord, I have given the list of dates to your lordship. My lord, the skip of the first date, the second, 5/9/22. The bids of 10 bidders, including that of petitioner and respondent 6, that is Brahmaputra Infrastructure, were opened by tender opening committee and checked by tender evaluation committee. My lord, this is the procedure they follow. Now, my lord, the most important part here is, I have pointed it out in my list of date itself, the petitioner, and this, my lord, there has been a
This is
suppression.
taking some time, then I may not be taking up any other matters.
My lord, it won't be possible. Others, my lord, may leave. I may say so because I will not be able to.
No, it's okay.
I'll try my best. Time would not be left for others to make any submission.
No, it's okay. That's what I'm freeing others. Mr. Mazumdar has a half SCC open.
Yes, my lord. I just wanted to place it, had my learned friend not started. Now that he has started, my lord, as your lordship has indicated, there are certain things which senior counsel, by saying that matter may be or may not be taken up, he did not stop at that, my lord, he continued. Possibly that doesn't apply to him in this case. At least. I know about his client.
You see, that is the beauty of sitting side by side. Yes.
My esteemed colleague not only knows about my client, they also are is fully aware of the counsel.
Why
himself.
not? He has a what you call a prefix in his name. Why will he not?
And I fight against his client, of course, for my client.
And your SCC is for which item?
So that case where your lordship, that MMR's case, Muslim Marriage Register.
Ah, right.
My lord,
Right.
There is a judgment I just wanted to point out.
Huh.
We are confronted with a situation where the 1942 Act says minor marriage can be registered. Supreme Court says that if there is a pre-constitutional law made by provincial legislature, which conflicts with a subsequent act passed by the
Just give me that
parliament.
citation. Give me that citation.
1995. 4 SC 104.
104.
4. State of Tamil Nadu versus Adhyaman Educational and Research Institute and others. Paragraph minor 13. 104
The state of Tamil Nadu versus
versus Adhyaman Educational and Research Institute.
paragraph.
Paragraph 13 and 22, minor. Bottom sentence, two sentences from the bottom. Now, in
Okay.
this case, the issue I'm
No.
issue was the Madras University Act of 1923, whether this will prevail or the AICT Act of 1987 will prevail. So it says no, there is an implied repeal. So in that view of the matter, this Assam Act of 1942 should be held to be implied repealed.
Okay.
My
Because
lordship
both are
is,
both subsequent POXO and as well as my lord this prevention of child marriage act by parliament.
Okay.
Yes,
my lord is going to
just-
hear the matter.
No, I'm not hearing it.
I-
I'm just taking
Let
a
my
plain
lord
issue
also
because
read the
this.
judgment, my lord,
My
so that he can.
Yes, yes.
No,
my
because
lord,
this is something which I asked the additional advocate general to,
Yes, yes,
to,
I can
to respond to the court query.
My
That is why when he made that statement, I recollected what the question was, and therefore I have just taken that
Still
satisfaction.
have a
Lord,
direct
I have-
hearing on the question.
Lord, I have also a little bit of preparation I have
No,
done.
no, no,
And
there
my
will be a
case.
full-fledged hearing. I'm just pointing out since your
My
lordship has said, but
No, because this is a query put to the additional advocate
Yes,
general on
yes.
that day, specifically put.
yes.
So we'll
Lord-
take up the hearing. I'm
My lord,
just,
what has happened, a little submission, my lord, if my lordship allows me. My lord, what has happened during the operation of the interim order in this case, the Muslim marriage register had been suspended, my lord. And his suspension order has been put into challenge in another writ petition, my lord, wherein his suspension has been stayed, my lord. So both the matters is required to be heard together, my lord.
I'm not clubbing it right now,
My
but
lord,
I'll take it up.
Lordship will take it up some other day.
My lord.
Yes,
Give a fixed date in this matter.
Fine.
Additional advocate general is there. Give a fixed date.
Item 13, my lord.
item
13.
item 13. There are date. Yes,
Yes, Mr. Tiwari.
My lord, the
Alright.
point to be noted
Item
is,
11 and 12 will also not take place.
No, it will not take
So
place.
let it be on Tuesday, my lord.
He'll do it. Tuesdays, I think it's better to have it in a regular weekdays.
I leave it to you. It has to be hard because only question of law is there.
किस हाल में साहब ने दी दो? Yes, Mr. Tiwari.
my lord, point to be noted is that the.
Just tell whatever you have to say. Tell the court pastor.
Can you tomorrow, my lord?
Point to be noted is, my lord, the petitioner's bid in this case was found responsive. So petitioner is not aggrieved by the fact that his bid was not found responsive. His bid was found responsive. He is very much in the field. He is aggrieved by the fact that the bid of respondent 6 has been found responsive. The case of the petitioner is the bid of respondent 6 ought not to have been found responsive by the NHPC. And petitioner is also aggrieved by the fact that NHPC, by providing an opportunity, added opportunity to respondent 6, made his bid responsive. That is the core of the issue. Now, my lord, while dealing with this very core, another important aspect to be taken note of is,
We can take note of the English proverb also. Cut the competition at the bud.
yes, my lord, that's why I'm coming to that straight away. Now, the bid of the petitioner was found responsive by following a procedure and by giving it an opportunity, which was also given to respondent 6. There has been a separation of material fact in the writ petition that the petitioner's bid documents were equally defective, and petitioner was provided that very opportunity to correct the defect and to furnish new documents, which the petitioner did, and the respondent 6 did likewise. Now, in the case of the respondent 6, petitioner has come out with all guns blazing, saying that, look, this opportunity was given. This is how he could do it. This document was furnished. The fact is, the same thing was done with the petitioner also. And this is what I'm going to project before your lordship.
It hardly take 10 minutes. You said that you can't finish in the entire day.
My lord, at least the core I have addressed. Now, my lord, I come with that very important aspect. The petitioner. 5922, lordship, I have 1 and 2, may kindly. The petitioner had not submitted power of attorney and board resolution with the tender as required under clause 3.1a of the NIT. Lordship may see, clause 3 deals with the qualification of bidder. 3.1a, page 26 of the writ petition. Page 26, 3.1a. Lordship may see at the very top.
Page 26.
26. Copies of original documents defining the constitution or legal status, place of registration, and principal place of business, written power of attorney of the signatory of the bid to commit the bidder. Additional information as sought in the Form 1 General Information, Section 3 shall be provided.
Which one?
So this is the part of the qualification of bidder.
No, 26, which clause?
My lord, 3.1a.
Yes.
Yes. It reads, my lord, it is under the heading qualification of the bidder. 3.1 says all bidders shall include the following information and documents with their bids in qualification information unless otherwise stated in the ITB. A says copies of original document defining the constitution or legal status, place of registration, and principal place of business, written power of attorney of the signatory such and such. This is the requirement. So, my lord, the petitioner, while submitting its bid, had not submitted power of attorney and board resolution with the tender, which is the requirement under clause 3.1a. And also, my lord, class 1 contractor registration certificate issued by government and semi-government department is required under clause 3.2 capital AC. 3.2 capital AC, my lord, will find again at page 26 only. 3.2 capital AC. The bidder must be a registered contractor.
No, what he did not furnish, he did not
Below
submit.
two things. Number one, power of attorney and board resolution, thereby violating clause 3.1a. He also did not furnish class 1 contractor registration certificate issued by government and semi-government department.
Class 1A.
Yes. Class 1 contractor registration certificate.
Class 1 or
Class 1 or class A. Alternatively, my lord, it is the same thing. Either class 1 or class A. Contractor registration certificate.
No, there is also a clause 1A.
My lord, that it is not the requirement. I correct myself.
Okay.
The requirement is class 1 or class A.
Achha.
Contractor registration certificate. Which is the requirement under clause 3.2 capital A within bracket C. At page 26 itself, my lord will find this clause 3.2 capital A C. The bidder must be a registered contractor with any government, stroke semi-government departments, NSPC registration certificate allowing for undertaking work equivalent to estimated value within bracket class 1 or class A, or as the case may be, shall be submitted along with the bid. Shall be submitted. So these two documents, my lord, they are not furnished by the petitioner, thereby violating clause 3.1a and clause 3.2 capital A within bracket C of the NIT. Likewise, my lord, the respondent 6, which is Brahmaputra Consortium Limited, had also submitted with its bid an EPF registration certificate. It had submitted along with its bid an EPF registration certificate in the name of Brahmaputra Consortium. The EPF certificate was in the name of Brahmaputra Consortium instead of Brahmaputra Infrastructure Limited, thereby violating clause 3.2 capital B1. I'll read this again at page 26. 3.2 B1. Page 26 at the very bottom, my lord will find. Each bidder must also produce with their bid PAN number, GST registration number, and my lord, this is important, EPF registration number. My lord, the requirement is you should furnish EPF registration number. Number was there. The difficulty was Brahmaputra Consortium was written there. Brahmaputra Infrastructure Limited was not written there. I will demonstrate before a lordship, the number remained the same. There was no change in the number. There was change of name. So the opportunity was given to both. Opportunity was given to both, and not only to both. Such opportunities were given, my lord, to all total 6 out of 10 bidders. There were 10 bidders who had submitted their bids. 6 out of 10 bidders were provided with the opportunity of
furnishing additional information or documents along with their bid. So there was a level playing field. The rest 4 Milord defects were such that NHPC felt no purpose will be served. And here, Milord, I will also show the relevant clauses. The clauses is that if while submitting the bid, the document is already in existence, it is with you, such documents can be furnished. But if the document is not in existence, you can't manufacture it and then give it. So something which is already in existence, opportunity will be provided to you, correct it, show it to us. Then you are qualified. So level playing field was there. I reiterate, Milord, this is the relevant aspect which was suppressed in the writ petition. This by itself should disentitle the writ petitioner to seek any relief before a lordship. Suppressing this fact, demonstrating that there was a bias in favor of respondent 6, that a discriminatory treatment was given, Milord, they obtained this stay order. Then the next date is 29/9/22. At the stage of bid evaluation, the TEC noted certain infractions in the bid of the petitioner, respondent 6, and others. Accordingly, now, Milord, under what clauses we acted? I am showing those clauses. The first is 16.4 and second is 21.4. This, my lord, will find page 57 and 59 of the writ. 16.4 at page 57 of the paper book.
Yes,
Any
clause
alteration, stroke, I'm sorry,
16.4.
16.4 at page 57.
Yes.
Any alteration, stroke modification in the bid or additional information supplied subsequently to the bid after period of bid submission. Now, this line is important. Unless the same has been expressly sought for by the employer shall be regarded. So the employer can expressly seek for some documents or additional information. Unless the same has been expressly sought for by the employer, shall be disregarded. On your own, you can't. But employer can ask you to furnish. Next is 21.4. 21.4, my lord, will find at page 59 of the paper book. It is under the heading examination of bids and determination of responsiveness. 21.4. Page 59. 21.4, I read, during techno-commercial bid evaluation, the employer may, at its discretion, ask any bidder for a clarification of its bid. The request for clarification and response shall be in writing or email or through the portal. However, no change in the price or substance of the bid shall be sought, offered, or permitted. Reply shall be submitted by bidder within a stated reasonable period of time. If bidder does not provide clarifications of the information requested by the date and time set in the employer's request for clarification, its bid may be rejected. This is 21.4. Now, apart from this, my lord, there is equally important, my lord, clause which is in Manual for Procurement of Works. This is para 5.4.5 of the Manual for Procurement of Works. This, my lord, I'm sorry, this I'll show to your lordship. Manual for Procurement of Works of NHPC.
Give one to Mr. Bora also.
Yes, my lord, that I'll.
Yes.
5.4.5. This, my lord, will find internal page 73. Internal page of this. Relevant portions, my lord, I have brought. My lord has got it? Yes. Clarification of bids stroke shortfall documents. During evaluation and comparison of bids, the procuring entity may at its discretion ask the bidder for clarifications on the bid. The request for clarification shall be given in writing by registered stroke speed post, asking the tenderer to respond by a specified date, and also mentioning therein that if the tenderer does not comply or respond by the date, his tender will be liable to be rejected. Depending on the outcome, such tenders are to be ignored or considered further. No change in price or substance of the bid, including specifications, shall be sought, offered, or permitted. No post-bid clarification at the initiative of the bidder shall be entertained. At the initiative of the bidder shall be entertained. Then is relevant portion, my lord. The shortfall information, stroke documents, should be sought only in case of historical documents which pre-existed at the time of the tender opening and which have not undergone change since then. So, my lord, while submitting the bid, if the document already existed, which has not undergone any change, if we want, we can ask for it.
I mean, it has to be historical.
Historical in the sense that it existed at the time of the opening of the bid. At the time of the tender opening, which have not undergone change since then. That means, my lord, after the opening of the tender, you can't create a document. Document should exist already at that very point of time. If accidentally you don't give it, we can ask for it. Then, my lord, apart from this, this is already annexed. There is para 7.1 within bracket 4 of NHPC Contract Manual Volume 1, which is annexure R1 of the AIO. This was read out. It talks about the minor infraction, correction of the minor infraction. Now, one may argue it is not minor, it is major. Be that as it may, we have the power, the discretion to ask for the documents if it is not there while submitting the bid. And this, my lord, we asked in the case of 6 bidders, not in the case of only 1. So, my lord, the next page, my lord, will find. Accordingly, the NHPC prepared draft letters dated 29/9/22, seeking clarification from the respective bidders about the nature of infractions noticed in their bids. However, these letters were officially issued by email only on 13/10/22 to all the concerned bidders, including petitioner and respondent 6, whose bids had one infraction or the other and could be cured by furnishing documents, information, and clarification. The draft letter may not be annexed in the writ petition. So far as we are concerned, we have annexed the email itself in our affidavit in opposition. The email is 13/10/22, and this, my lord, will find annexure R3 of our affidavit in opposition.
It's okay, we did not go through it. Is there anything book this?
Yes.
We not read that.
Very well. So, my lord, I'm cutting it short. So we annex the email. Annexure R3, my lord. Annexure R3 email was issued to the petitioner, pointing out power of attorney, class 1 registration certificate of contractor, all those things you furnish. So far as respondent 6 is concerned, it is annexure R2 of the AIO. Below the page is page 282 and 283. I'm sorry, there is a typographical error. 281 has been mentioned. It is 282 and 283 in the list of dates that I've given.
On 13/10.
Yes, my lord, 13/10.
275 to 281, it should be
282 and my lord, it is before that.
281 to 283.
281 should read as my lord 282. 282,
283. Okay.
282 will be covering letter, 283 will be the email straight away.
Yes.
Telling the respondent 6 that look, the challan you have given, showing the name of Brahmaputra Consortium, that Brahmaputra infrastructure, this is what we want. And my lord, the important thing to note is, it is the number which is required. Basically, we are interested in number. There was no change in the number, I will show that. So the 2 letters were issued. Now, my lord, such emails were sent, as I pointed out, to total 6 bidders out of 10. Now, my lord, on 14/10/22, the next page, on 14/10/22, respondent 6 via email submitted an EPF challan in the name of Brahmaputra Infrastructure Limited. Annexure R4 of the AIO. My lord, this I will show because there is lots of controversy on this. Page 286, 287 of the AIO. My lord will see 287.
Thank you.
287 of the AIO. Left hand side at the very top. Establishment code and name. This is the number. The relevant thing is DL, the first, and then my lord, lordship will leave all the CP, MWO, etc. 35337.
This
This is the number, EPF number.
287.
Yes, my lord. 35337 is the number. DL 35337. All of those are computer
Where are you
codes.
reading?
My lord,
Establishment code name.
287 establishment code and name.
Okay.
This is the number, EPF number. My lord will find the name is Brahmaputra Infrastructure Limited. The requirement, my lord, of the clause 3.2b is the number we are interested in, not that you have to furnish a certificate. Number we wanted, what they had furnished earlier was consortium. Brahmaputra consortium was written, not the Brahmaputra infrastructure. When we send them the email on 14/10/22, this is, my lord, they sent to us.
As per your tender, you only wanted the code.
Number,
They gave the right code, but gave a wrong document.
wrong name, Brahmaputra consortium. The reason was there was a change of name. The change of name happened earlier before their submission of the bid. From consortium to infrastructure, but the EPF number remained the same. But this name also, the challan they gave, this is the number. For example, my lord, I will clarify. I asked for the old copy, the which they had furnished earlier. Brahmaputra consortium, lordship will see that. I asked for it. I have marked it with yellow pen, the number. Same thing. It is DL 35337. Brahmaputra consortium is written there. Left. Top. Name is Brahmaputra consortium. You are hereby allotted code number DL stroke 35337. This is the number. So it is this document, my lord, they had given with their bid. We sent them the email. They sent with the change of name, Brahmaputra consortium, the challan, showing the same number. Now, my lord, the level playing field, the next date.
Now, my lord, the next date shows the level playing field, 2010-22.
Yes.
2010-22 shows level playing field. On 2010-22, petitioner submitted a class 1 contractor registration certificate and a copy of the resolution of the board of directors. He had not given it earlier. Emails were sent to both, not only to both, but to 4 others. But 4 others may not be such nincompoops. They could not give the adequate documents, even after giving a chance. The 2 took the opportunity and corrected the defects. Petitioner does not talk about itself. It talks about the respondent 6. Then, my lord, 29/11/22 report of tender evaluation committee. Herein lies the catch. On 29/11/22, the tender evaluation committee in its report evaluated the techno-commercial bids of 10 bidders. This I will show to your lordship. Page 217 to 237. 217, lordship may see of the writ petition. My lord, at the bottom, after all the 10 names, lordship will notice, I just read whether my lord has got page 217 of the writ petition. Page 217 of the writ petition. The report of tender evaluation committee dated 29/11/22.
Yes. This we have seen.
Bottom, below, I'm just pointing out the relevant portion of it. At the very bottom, lordship will see after the names, tender evaluation committee duly constituted at note such and such has gone through the technical bids submitted by the above participating bidders and has sought clarification from the bidders. The details of clarification sought from bidders and responses from the bidders is as detailed below. Lordship will find total 1, 2, 3, 4, 5, 6 names. As I said, out of 10, clarifications are sought from the 6, including petitioner and the respondent 6. Now, my lord, details in respect of respondent 6, my lord, will find at page 223.
Just a moment.
I'm sorry.
What is the name of the petitioner firm?
Petitioner's firm is JLD Construction. JLD Construction, my lord, will find among the top 6 at serial number 5.
5.
Brahmaputra Infrastructure, the respondent 6, my lord, will find at serial number 2. All 6 names are given, all the firms which were asked to give their clarifications or furnish the documents. We have given the entire chart. It was all fair, my lord, transparent. Lord, my lord, what happened in the case of respondent 6 was, can be seen at page 223 and 224 of the paper book. At 223, details are given in respect of respondent 6. At page 224, my lord will notice at column 10. Page 224, column 10. Valid EPF certificate. Submitted in the name of Messrs. Brahmaputra Consortium Limited. Remark, not as per NIT. This is incorrect. Because, my lord, on 14/10/22 itself, Brahmaputra Infrastructure Limited had furnished the challan showing the EPF number with the name Brahmaputra Infrastructure. And that challan was not there before tender evaluation committee, or they ignored it, we don't know. It was ignored. And then this remark was given. Now, how it came to the notice of the NHPC, my lord, will be seen. I'll show that. How they realized. So therefore, my lord, straight away, the recommendation was of the tender evaluation committee. The recommendation, my lord, will find at page 237, recommendation to open the price bid of the following techno-commercially responsive bidders, SIPL Infracon and GLD Construction. There were two. The Brahmaputra infrastructure was not there. Now there was a review. SIPL was out. GLD was found responsive. It remained responsive, and the respondent 6 entered into the picture. In this very particular writ petition, my lord, SIPL has not come before the Honorable Court. SIPL has not come before the Honorable Court in this case, saying as to we were also found responsive, why we were made unresponsive. So that aspect I will deal in the next case, because next case writ petition is also by SIPL, pertaining to different contract but same flood control measure. Here GLD was responsive, it remained responsive, but instead of SIPL, Brahmaputra infrastructure came into the picture and SIPL was out in the review. Now, my lord, there is a procedure, my lord, in NHPC, and that procedure I will show. In my note, my lord will find page 3, the last portion, with the star marks. The report of the TEC dated 29/11/22 was forwarded for financial concurrence and approval of executive director in terms of paragraph 7.5 of the NHPC contract manual, volume 1, read with remarks, Roman 7 of clause 2 of section 1 of delegation of power and annexure 5 of DOP containing policy guidelines for financial concurrence. I will just produce the note sheet, my lord, to show how it works. It's, my lord, many of the pages are in Hindi. I have got it translated, but since Hindi won't be a problem for your lordship. So, I think Hindi portion I have translated also. We will give him. There, my lord will find internal page 20. From there, the real action begins pertaining to this case. What we are dealing with. This is, my lord, the note 61 deals with the recommendation of tender evaluation committee dated 29/11/22. The note 61 deals with that. It clearly says SIPL Infracon, GLD Construction, these two, my lord, were recommended. The English translation is separately I have given of the Hindi portion.
Yes.
Note 63, my lord, will find this was the recommendation was processed and General Manager PNC Babitendra Kumar, note 63, उपरोक्त प्रस्ताव के अनुमोदन की सिफारिश की जाती है. Page 21, note 63. He clears it in terms of the recommendation of TEC 29/11/22. Note 61 is forwarded for approval by General Manager. Note 64, my lord, because after it comes to the ED, Executive Director, for his approval, I will show the powers. It comes to ED. Note 64, for financial concurrence, my lord will find note 64, there is a name, Vipin Gupta, Executive Director, SLHEP, Subansari Lower Hydroelectric Project. In note 64, ED forwarded the recommendation for financial concurrence to General Manager Finance. Note 65, note 66, it comes to General Manager Finance. General Manager Finance then They look into it. The scrutiny takes place by finance. And then, my lord, the discovery, my lord, is by manager finance, Krishnendu Pal. He gives the note. This is the part of note 66. Krishnendu Pal at page 22. I have given the English translation. Hindi portion I read, my lord, which is in original. I read, my lord, दस्तावेजों की जांच के उपरांत ये पाया गया कि वन मिसर्स SIPL इंफ्राकॉन एक पार्टनरशिप फर्म है जिसने की इस बिड प्रोसेस में हिस्सा लिया है। यद्यपि इस बिडर द्वारा CP 2036 पर संलग्न किए गए क्लास 1 रजिस्ट्रेशन सर्टिफिकेट के अनुसार मिसर्स SIPL इंफ्राकॉन प्रोप्राइटरशिप फर्म है। वित्त विभाग के अनुसार CP 2036 में संलग्न किए गए दस्तावेज के अनुसार मिसर्स SIPL इंफ्राकॉन ए पार्टनरशिप फर्म को रेस्पॉन्सिव बिडर नहीं मान सकते हैं। अतः इस बिडर के मूल्यांकन वी आर नॉट कंसर्न विद SIPL। देन कम्स ब्रह्मपुत्र इंफ्रास्ट्रक्चर। मिसेस ब्रह्मपुत्र इंफ्रास्ट्रक्चर लिमिटेड ने EPF रजिस्ट्रेशन सर्टिफिकेट बेसिस ब्रह्मपुत्र कंसोर्टियम लिमिटेड के नाम पर जमा किया है। इस बाबत स्पष्टीकरण मांगने पर, दे आर टॉकिंग अबाउट द क्लैरिफिकेशन सॉर्ट, स्पष्टीकरण मांगने पर EPF रजिस्ट्रेशन सर्टिफिकेट की जगह EPF चालान संलग्न किया गया। संलग्न किए गए चालान 2033 से ज्ञात होता है कि एस्टैब्लिशमेंट कोड एवं नाम DLCP M00353337 सच एंड सच एवं ब्रह्मपुत्र इंफ्रास्ट्रक्चर लिमिटेड के नाम है। अतः वित्त विभाग के अनुसार इस बिडर के मूल्यांकन की पुनः समीक्षा का सुझाव है। सो द रिव्यू, इट इज देयर। Accordingly, it was reviewed by the TEC and the consequences followed. Now, my lord, I will just show the power of NHPC. Para 7 within bracket Roman 5 of NHPC contract manual. The contract manual my lord, page 32, internal, Roman 5.
Yes.
After concurrence of finance, the recommendations of the tender evaluation committee shall be put up to the appropriate authority for consideration and approval. Shall be put up to the appropriate authority for consideration and approval. The appropriate authority is ED for its consideration and approval. After concurrence of finance, the recommendation of tender evaluation committee shall be put up to the appropriate authority for consideration and approval for opening of price bid or award of work as the case may be. Pursuant to the approval of the competent authority, concerned department responsible for award of tender shall intimate the techno-commercially qualified bidder the date, time, and opening of the price bid. So, my lord, the appropriate authority is not merely a, my lord, titular head, but there has to be, my lord, the consideration and the approval. It is not mere approval. It's not an empty approval, but consideration and approval. So the mind has to be open. There is an application of mind which is required while approving it. 7.5. Likewise, my lord, in the remarks 7 of clause 2 of section 1 of delegation of power, the same power is vested. The delegation of power extra copy है. नहीं देखो कोड कहाँ है, ये एक्स्ट्रा है.
But why these were not annexed to your affidavit?
I'm sorry, not annexed, but reference is made. So delegation of power. Yeah. 7. Seven says, my lord, wherever two envelope system of bidding are resorted to, the techno-commercial evaluation report and opening of price bids shall be approved by the authority competent to approve the call of tender.
You're reading where?
In Romans 7, my lord, at the
Seven.
bottom.
Okay.
Wherever two envelope system of bidding are resorted to, the techno-commercial evaluation report and opening of price bids shall be approved by the competent authority. So approval is necessary, and Lordship has seen the earlier clause, consideration and approval. So application of mind is must. So therefore, my lord, we come to the next date in the list of date, 10/12/22. It is a revised is the revised tender evaluation committee report. It is impugned in this case. Tender evaluation committee re-evaluated the techno-commercial bid of the respondent 6 and taking into consideration the EPF challan submitted by respondent 6, adjust its bid as techno-commercially responsive along with that of the petitioner. My lord, page 238 to 39 of the writ petition I will just show. My lord, 238 of the paper book. There are two. My lord, SIPL, we are not concerned, they have not come in this writ petition, challenging the decision as to why they were made non-responsive. Para 2, Brahmaputra Infrastructure Limited, Brahmaputra House such and such, the firm had not submitted EPF certificate in the name of the bidder, Brahmaputra Infrastructure Limited, as required against clause 32B1. The firm was asked to submit the same. Against the same, the firm has submitted a copy of EPF challan only wherein the name of the firm is mentioned as Brahmaputra Infrastructure Limited, the name of the bidder. During the deliberations, the committee was also informed that the bidder, Messrs. Brahmaputra Infrastructure Limited, has submitted a document issued by EPFO, Regional Office Delhi, regarding the change in the name of EPF registration from Messrs. Brahmaputra Consortium Limited to Messrs. Brahmaputra Infrastructure Limited in the tender document for the work, riverbank protection erosion control measures on the left bank of river Subansiri, such and such, while NIT number such and such dated 10/12/21. So, my lord, in the earlier tender, on 10/12/21, the information was already available with the NHPC regarding the change of name. That information they had furnished. So they knew it regarding the change of the name, the efforts made by them, and subsequently the challan. The committee opines to consider the same towards qualification of the bidder in this tender. In view of the same, the firm qualifies the tender condition of the NIT. The TEC recommends to consider the bid of Brahmaputra Infrastructure Limited as the responsive. So two things. Number one, the challan, showing the number of the EPF, showing correctly the name Brahmaputra Infrastructure, and also the information already available with the NHPC earlier in connection with the earlier tender that there was a change of name. They had submitted the document that they are changing their name from consortium to infrastructure. So two things were considered. Now, my lord, being confronted with this situation when these developments started happening, then petitioner started crying foul. On 15/12/2022, files a complaint to executive director alleging irregularities in tender process. I will skip it. There is a reply which NSPC gave also to the complaint. Reply also I have annexed. Then 27/12/22 TEC recommended the opening of the price bid of the petitioner and respondent 6 and forwarded the report for approval of the director. I will skip the annexure, my lord, considering the time, not very, very important. Because both were there, petitioner and respondent 6. 28/12/22 TEC report dated 27/12/22 was accorded financial concurrence and the executive director approved the opening of the price bid of the petitioner and respondent 6. Then 28/12/22, which is impugned, along with the revised report of TEC dated 10/12/22. 28/12/22, the price bid of the petitioner and respondent 6 was opened by tender opening committee on 28/12/22 online on Central Public Procurement Portal, and respondent 6 was declared as the lowest bidder L1 with a quoted bid of 4,99 lakh, I think it's 1,253, such and such. Annexure F of the writ petition. So, my lord, the respondent 6 turned out to be the lowest bidder and the price bid was opened. This is under challenge. 5/1/23, the TEC evaluated the price bid of respondent 6 and recommended awarding of work to respondent 6 at the quoted price of 4,99 lakh, such and such. Thereafter, the TEC forwarded its report to the executive director for financial concurrence and approval, as usual. Annexure R7. Thereafter, my lord, the interim order came of the Honorable Court. 9/1/23. So, my lord, after 5/1/23, nothing could be done. Matter stopped there. So now, my lord, my submission is.
You close now?
Yes.
You are
But
basically
tomorrow
over.
I beg your pardon?
Basically, your argument is over.
The factual part. I can place case law submissions.
It goes to next week.
Yes.
27.
Mr. Bora, 27th?
Yes.
Regarding the second matter, we have not started the second matter. We are arguing the first matter. He is replying the first matter, item number 11.
Yes, yes, 11 only. 11.
11.
12 years.
What's up?
Once, my lord, we complete our argument, our headache is gone and my lord's headache begins.
Taken away my smile.
That is it. I think. My lord is also rising, so better we wait. Seems, my lord, they all thought that lordship possibly will be sitting till late because lordship already has earned the reputation of working till 7 p.m., 8 p.m. So sometimes, they entertain such doubts.
Man, therefore, I have been rewarded with slip disc.
Oh, yes, that's quite painful, very painful.
So for what I've done, I have earned. Mr. BP Bora. Counsel for the petitioner is present. The submissions of Mr. P.K. Tiwari, Senior Counsel, assisted by Mr. R.J. Das, Counsel for the NSPC, remains inconclusive. List again on 27/7/2023.
Interim order.
Interim order passed to list stands extended till the next date of listing. Yes, Mr. Datta.
The production list 2 and 3 matter, my lord. Production list 2 and 3 matters, my lord.
Hmm.
The council, they have, both of them are left, my lord, I'm told.
Okay.
So, my lord, the problem is that the no confidence motion is tomorrow. One of them is tomorrow, my lord. The vice president is day after tomorrow.
Kali, did you skip the? Okay. Production list. Due to positive time matter could not be taken up today. List on tomorrow.
21.
Deeply obliged.
So go anything, any matter? It's a Google. I desire to tell you this. This Mines and Minerals book was written by you.
Compiled by us.
Huh?
Compiled by us.
No, it's okay.
Yes.
Compiled by you. Which bookseller is having this? Because my library said that it is not available.
So I'll provide copy.
No.
I have the copy.
No, but which bookseller has, because I need it for the courtroom.
Tomorrow I'll.
No, you don't have to supply it because they'll have to procure. They have their own ways to procure it.
I have the copy. I will.
No. You see, ultimately you are an author of a book. We don't want it that is, but the question is that my library has to go somewhere and get it. Which vendor is selling it?
Lordship, in old court building.
Huh?
Old court building.
Old court building, it is available.
Lordship, I will provide tomorrow.
No. Don't give it. The library has to procure not one copy. We'll have to get more. In the old building in that corridor, we'll get it.
And our high court already purchased 75 copies, high court 25.
Because I was told that it is not available. That's what I am asking, because I gave a requisition for that book for the court.
Lordship. High court already purchased.
Okay, I'm not aware that they have already purchased 75 copies.
Lordship,
Not available.
Lordship.
Okay, then we'll get it.
Lordship. You could not, I can bring tomorrow also.
No. You have given me one, I have it. But I require it for the court purpose. I gave a requisition, but I was told that it was not available. But now since you have said
High
that
court has purchased.
High Court has purchased, then it's okay, we'll get it.
Lordship.
Because it must be recorded and then it will come back.
Lordship.
খালি আছে তো আপুনি বাইদেউ মাৰি দিব লাগিব কৰাই দিব না যাতে কাম দিছে পাব বাইদেউৰ লগত যেনে মাৰি দিব লাগিব সংশোধিত কৰি কথা সেইটো এইটো মই 10 টকা চাম সেই দুটা বাইদেউৰ লগত দি আছো এই 10 টো ঠাকুৰে 10 থাকক বড়া কৰা মই কিবা এটা বস্তু চাই আছো আৰু এই দুটা বাইদেউ মাৰি দিব অৰ্ডাৰ আছে লৈ খালি আছে মই কৰিব লাগিব